For reasons mentioned in the order, the petitioner is allowed to go on bail of rupees 1 lakh with two sureties of like amount, one of whom should be a government servant and a resident of the state of Assam with certain conditions.
Obliged. May I please your wish?
Yes.
Well, item 65 minutes, was fixed for Kilday. I have some personal difficulty, but Kilday has not come up. So date will be fixed for CD minute. 65 minutes.
60.
No entry is here.
Heard Mr. Ainuddin, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor, who prays for some more time for producing the case and prayer is allowed. This case is, let this case be listed down.
Immediately after vacation, maybe on 18th.
On 18.
Yes.
Obliged.
7.
Mayor, your lordship. Lordship, I have filed an interlocutory application for correction of an order passed by your lordship. Can it be taken up today, lordship? Obliged.
May I please? My lord, I beg to mention for listing of anticipatory bail, my lord, for tomorrow or day after tomorrow.
It will come in due course. Whole week is motion week. It will come in due course.
Hello.
May it please your lordship?
May I please, your lordship? Lordship, I beg to mention item number 50, lordship. Matter will be adjourned for today, lordship.
Why?
Lordship, this MP Bora is out of station. He has just instructed me on telephone, lordship. And N Devi, she has expired recently.
Heard Miss
S.E. Ahmed. E. Ahmed.
S.E. Ahmed, learned counsel submitting on behalf of Mr. M.P. Bora, learned counsel for the appellant, who prays for an adjournment on the ground that the counsel for the appellant is out of station. And another engaged counsel, Ms. N. Devi, has already expired. Considering the grounds mentioned by the learned counsel, the prayer is allowed. Let this matter be listed
After vacation.
after vacation.
May it please your lordship? Lordship, I beg to mention item number 40 and 67, lordship. In both this case, lordship, we are on interim bail, lordship. Kesari is not there, lordship. May I pray, lordship, let the matter come up after vacation, lordship. Item number 40 and 67.
40 and 67.
Yes, sir.
Learned additional public prosecutor prays for some more time for producing the case diary. The prayer is allowed. Let this
On
matter be
24/7.
listed on 24/7. The interim order shall continue till next.
Highly
obliged. May it please, your lordship, I beg to item number 4, my lord, as per my instruction of the petitioner, may be allowed to withdraw, my lord.
Item number,
4, my lord.
what is your name?
M. Hussain.
Heard Mr. M. Hussain, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. Considering the submissions, the prayer is allowed. This bail application is dismissed on withdrawal.
Obliged.
May I please, your lordship? Lordship, I beg to mention item number 17. Maybe I may be allowed to withdraw.
17.
17, lordship.
What is your name?
KK Hendy, lordship.
Heard Mr. K.K. Hendik, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. Prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Highly obliged.
May I please your lordship? Item number 68, my lord. Orders matters, my lord.
Yes.
They have been wrongly listed, my lord. It is parted before the bench of Honorable Mr. Asif Chaudhary Chaudhary, my lord.
Heard Mr. N. Mahajan, learned counsel for the petitioner, who submits that this matter has been wrongly listed under orders column, as the same has been kept part heard by a coordinate bench of this court within bracket, Honorable Mr. Justice Edikos Chaudhary. Registry to list this case before appropriate bench.
But tomorrow there is a single bench. Madam. For Mr. Justice on editor.
No, registry, you have to make,
Yes, ma'am. Obliged. Another prayer for listing, madam, a regular bail. Madam.
regular bail will motion.
Motion call. Madam. For
Oh.
42406.
Whole week is motion week. It will,
Kindly, madam. Because only case diary would be required.
no preference. It will come in due course. Whole week has been declared.
Only one regular bail, madam. Because case diary would be required. We are seeking early date before vacation because he's a heart patient, madam. He recently underwent coronary artery bypass surgery, madam. So
What is the matter?
42406, madam. He has been shown arrested, madam.
Okay.
Obliged, madam. Highly obliged.
May please your lordship. Lordship, I beg to mention item number 43, lordship. Matter was urgent for the day, lordship, as my senior is out of station.
On request of learned counsel for the petitioner. This interlocutor, what is your name?
A Das on behalf of T. Devi, lordship.
A Das submitting on behalf of Mr. T. Devi, learned counsel for the petitioner. This criminal appeal is adjourned for 2 weeks. 2 weeks.
Yes. May it please your lordship. I beg to mention an item, anticipatory bail application for listing, your lordship, for tomorrow. It's a motion matter.
Listing will come in due course.
There is some urgency. your lordship.
All matters are urgent. You,
The accused petitioner stays in Tamil Nadu, your lordship, and there is some urgency because the learned court below has rejected his bail application. AB.
it will come in due course.
Highly obliged.
May I please your lordship. Lordship, I beg to mention item number 5, lordship. Lordship, we want to withdraw the case.
What is your name?
R alone.
Heard Mr. R. Alam. Your name is not there. You are submitting on whose behalf?
On behalf of S Hope.
Submitting on behalf of Mr. S. Hawk, learned counsel for the petitioner. Praying for allowing the petitioner to withdraw the instant bail application. Prayer is allowed. This bail application is dismissed on withdrawal.
May it please your lordship. Lordship, I beg to mention for listing of a bail application, lordship. It was last listed on 10th.
What is the
It was-
matter?
It's a bail application, lordship, NDPS matter.
NDPS senior courts.
This is a matter was part heard in this court and the matter has not been listed since April. And once it was listed in May, but it got left over.
Part heard.
Yes, but it doesn't reflect part heard in the order, but it was part heard by your lordship.
But
So,
if it is
and
not.
so, and
mentioned-
it's also a motion week and then the vacations are coming. And it's going to be 1 year since the stay has been on. I mean, it's a stay for 1 year. So
What
I'm
is the
greatly
matter?
suffering. It's a bank fraud matter. Going on in
No,
CZM.
Is it a criminal revision or
It's a criminal petition.
criminal petition?
Yes, criminal pet.
No,
I just seek your lordship some kind of guidance in this because number of courts have also said that they're not going to take up the matter because there are substantial questions of law. And your lordship had passed an order for final hearing. I'm aware that this is a motion week, but I'm seeking some kind of an relief here. If it's not listed this week, then it will be listed after vacation. I don't know when it's going to be listed.
no, if it is part heard, then let it
But
be.
it doesn't, for some reason, it didn't reflect on the order that it's part.
But-
It was fixed for final hearing by your lordship.
Let it be listed immediately after reopening of the
Immediately after
vacation.
vacation. A date may be given as per the court's convenience.
16 July.
Same July. High level.
May it please the lordship. Lordship, I am seeking your permission for listing of an interlocutory application for modification of an order passed by this honorable court, madam.
I pass the order.
Yes, madam. Wednesday, madam.
When?
Wednesday, madam. DPO.
May I please your lordship. I like to mention listing on BA lordship. Not on matter lordship.
BA would no
Tomorrow.
mentioning. because BA whole week has been made as a motion week. It will come up automatically.
My lord. My another.
That will be tomorrow, Lordship. I'm paying for tomorrow listing, Lordship.
No mentioning. Have you filed the petition?
Yes, Lordship.
When have you filed?
Today, Lordship.
You have not yet filed.
Today file, Lordship.
You have filed or not?
Lordship, file, Lordship, not registration number, filing number.
It will come up in due course.
Lordship, may I please your lordship, I beg to mention, this is regular bail. Today, it is, co-accused has, approached this honorable court, that is item number 6, your lordship. And I have filed today itself, your lordship, and the matter may be taken with the serial number, item number 6, your lordship.
No,
Out of same FIR, your lordship. And the petitioner is behind the bars since last 50 days, your lordship. And he is not name accused also, considering and detention period, your lordship. The matter may be taken with this item number 6, your lordship. Out of same FIR, your lordship.
No, but 6 will be, we will be calling just now after some time. We cannot delay item number 6.
If possible, then it may be taken after some few time, your lordship. Analogously, your lordship.
Okay, okay.
Deeply obliged. Another pair, your lordship. Out of same FIR, item number 33, that is bail hearing, your lordship. Out of same FIR,
What is your prayer?
lordship, the matter will be taken with 33, your lordship. Another, I have filed today, your lordship. That bail also, BA, your lordship. And
No,
see,
it will come in due course.
lordship,
I am for the item number 6 and 33, the same petitioner.
No, what is your prayer?
lordship, may take it analogously, your lordship. I have filed out of same FIR, and the petitioner is,
No, you have not yet filed.
lordship filed, already filed.
What is your prayer? You want an unlisted motion.
Unlisted motion, your lordship. We taken with item number 33.
It will otherwise also come before this court if we take this
Yes,
matter. Okay.
Lordship.
Regarding item number 33, my lord, CD is available.
Then taken with the same,
Okay, yes.
highly obliged, your lordship.
May I please your lordship, I beg to mention item number 2. Lordship, this matter may be fixed at 2. I have informed the other side, lordship.
Item number 2.
Yes, lordship, other side is there, lordship.
I'll objection.
This is
Already
motion.
co-accused is in bail.
It is motion matter.
Motion matter.
Lordship.
We have called for the scanned copy of the records.
No, case report was not called
Not
for.
called for.
We'll call for today.
Okay, lordship.
File objection. Sir.
We'll take up the matter when it is called. Wait for some time.
Okay, lordship. Highly obliged.
I beg to mention for listing one AB lordship.
AB will be whole week has been made motion week. So it will come in due course. No need to mention.
Last
When have you filed?
filed on 24
What is the offense?
offense. Special arms act including lordship.
You are unable to say what are the offense. It will come in due course. Yes. Yes. You have filed the written objection.
Objection.
Yeah, we have filed our objection. That is in the record or not, lordship, I couldn't say.
In record of the senior counsel said that no need of record. Same, yes. The co-accused is on religion bail.
Okay, let the objection be called for.
Okay, lordship.
We'll take it up at 2.
Okay, lordship. Highly obliged.
It is in the law.
It's a big petition.
Well,
Yes,
my lord, in this matter, I am behind the bar for last 589 days, my lord.
So almost 2 years. No,
Almost 2 years.
no, not 2 years. Yes. 1 year, 5 months and all.
I was arrested on 13/11/2020.
we'll call for the scan copy.
22C. In fact, one decision I got where incarceration was for 1.5 years. And the Honorable Supreme Court said that we will not go into the second limb of Section 37 since he has stayed for so long. I think that is.
No, but there are several such decisions.
Ah,
You got one decisions.
several decision. One
But-
is where I got 1.5 years. Otherwise, so other cases
no,
are 2,
in-
3 years.
For 1.5 year,
Ah,
there are at least 4 to 5 decision of
Acha.
Supreme Court where only because of prolonged incarceration, 37 embargo has not been looked into.
My lord, I also got some decisions that these are very recent, where only,
Recently, in vacation court of Supreme Court also,
yes, in the month
somebody
of,
cited.
but that is not in consonance with the act, and we cannot question, of course. But
No, but there are other decisions,
hmm,
earlier decision of Supreme Court, which says that prolonged incarceration overrides the embargo of
Ah.
37.
had it been 2, 3 years, matter would have been understood. But then 1.5 years.
But in that what period would be long enough?
Ah, that
It is not clearly stated in any of the judgment.
Hmm,
But it appears that for 1.5 years incarceration, Supreme Court has given benefit of prolonged incarceration
for long
in
incarceration.
some cases.
Then again,
Let us,
depending
let
on
us
facts
call for
for the
the
CD, Lordship.
scan copy of the record. Heard Mr. M.A. Chaudhary, learned counsel for the petitioner, also
And who is it?
as Jahan, learned additional.
My lord's
Ah,
Perusal of the scan copy of the case record of special NDPS case number 159/22 would be necessary in this case. Hence, call for the same from the Court of Learned Special Judge Karimganj. Registry to issue requisition for the same. Let this case be listed again on 26/7.
it will be little bit earlier, my lord. 18 or 19 if possible, my lord.
18, we have so many cases.
18 or 19.
18, okay,
18 July.
18 July.
I'm deeply obliged.
वो आपको कुछ नहीं है। हाँ। आपको जो है,
Wait, please, your lordship. Lordship, this item may be taken up along with the
My lord,
33.
33, my lord, they have wrongly mentioned 33 is my lord Hatigaon PS. And item number 6 is Bosisto PS, my lord.
petitioner
Two
is
different case there, my lord. Not the same case there, my lord.
Petitioner is the same, my lord.
Petitioner may be same.
May
That
be same, my
doesn't-
lord.
And earlier, my learned friend mentioned,
So they mentioned by saying that, my lord, same case there.
Okay, let them wait till 33.
Yes.
Okay, we'll take you along
God
with
bless.
30.
May I please? My lord, this is for 39 application, my lord. I am behind the bar since 40 days, my lord.
wildlife
60 days,
protection.
60 days offense.
Hey, wildlife
My lord,
protection is not
FIR
there.
come forwarding page number 9.
Oh. This is actually Forest Department, I think.
Forest, no, I think it was PPL.
Oh, I'm not aware. This is Wildlife Protection Act.
What,
Beleg beleg law bole.
why the prayer was rejected?
My lord, prayer was rejected by the magistrate, my lord.
Where is the rejection order?
My lord, unfortunately, I have not annexed the rejection order, my lord.
That you have to annex. That is the requirement.
My lord, I have
Yes.
given a statement, my lord.
No,
Statement
that is
not
the
sufficient.
requirement under the
Then-
Guwahati High Court rules.
Then tomorrow, day after tomorrow, I will.
On request of learned counsel for the petitioner, let this matter be listed on 26th June.
My lord.
He'll have to
Hello.
file an additional affidavit, no?
Yes.
Yes,
Madam.
Lordship.
Hallelujah.
item number 8.
Yes,
please, the lordship. My lord, 439 applications. FIR at page 15, relevant portion, my lord.
when were you arrested?
It is, my lord, 9th of this month, my lord, 9/6. So today, my lord,
Perhaps he has also not moved. Oh, yes, the
Yep.
rejection order is there.
Where is the rejection order?
Page
rejection
24.
order page, my lord, 24.
Yes, very would be required.
My lord.
Heard Mr.
SC Das, my lord.
A.C. Das, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. Call for the case and fixing.
My lord, can it be on 28th of this month, the last day of
No,
imminent
These are all
vacation?
motion days again, it will be difficult.
And attempt first, my lord, if it is possible, my lord.
Come,
Otherwise, a short date, my lord.
on 15 July.
It's a long date, my lord. Any short date? that-
15 July is the reopening day.
That is the shortest,
Oh, vacation court, the notification is yet to come out.
15 July.
My lord.
This is application under section 439, and the accused person was arrested on 17/5/2024.
POXO is there, let the
Intellectual
notice go.
Notice will go to,
Actually, one inquiry was there and pursuant to that inquiry petitioner was called. Apprehending Harris Lordship, the petitioner filed his application. And thereafter Lordship, this honorable court has.
Case is not
there
registered.
is no case.
Yes,
It's not registered, but it is in the stage of inquiry. They are still inquiring. This is, of course, report was of May 24. 14th of May.
You are under interim protection.
Yes, Lordship.
What is to be done now?
Lordship, yes, in fact, the latest report has not come. What happened to the inquiry that they had done?
Let us call for the inquiry report. Your
Ah.
protection will continue.
Yes.
Yes.
Heard Ms. T. Stone, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. It appears from record that though no FIR has been registered against the present petitioner, an inquiry is going on against him.
Preliminary inquiry টা করি আছে। এইটা আমি register করবো পারে। হ্যাঁ।
Against him. And in that connection, he was called for. You were called by,
I went to the police station for delivering my statement, Lordship. They declined to record any statement because it said no case where to get the statement recorded. That is how.
let a report be called for from the officer in charge of all women police station as to whether any case has been registered till date against the present applicant and whether any inquiry is going on against him. If so, what is the fate of the said inquiry? Till receipt of such report, no coercive action shall be taken against the present petitioner. Let-
He already has an interim order, I think.
There is a
When, by which date? Date,
date, Lordship.
10-5 হওয়ার পরে?
10/5.
10/5,
But then it's not reflected in my petition.
in 10/5 it is not there,
Acha, then the matter came up on 14-5.
14/5 also it is.
Earlier interim may be continued, Lordship. That
No, when the earlier interim was granted,
Earlier interim কেটে দিছিল?
14/5.
14-5. 14-5, it's not there, Lordship said. মই এটা reflect করা নাই কিন্তু interim order.
No, no, December.
okay, no, we are giving it now. Till next date,
Not.
let this case be listed again on
Last part of July, Lordship.
25th of July. Or
They have not an execution order.
Interim order is
Petition.
today we are granting you protection.
deeply obliged.
এটা একটা লোকাল মুখে কাগজ নিয়ে করেছিলেন তাই তো? হ্যাঁ? নহয় নহয়।
None appears for the petition, the 11th of the
Item 11.
item 11. None appears for petitioner on call. It appears from order sheet that on last two occasions also, nobody had appeared on behalf of the petitioner. It appears that the petitioner is no longer interested in pursuing this anticipatory bail application. Hence, this anticipatory bail application is dismissed for non-prosecution.
And there was an interim order, I think, in
The
that
interim order shall
stand vacated.
stand vacated.
In item 12, instruction was called for ELR.
Huh? Hang on.
This meeting.
Item 12.
Yes.
Report from Kapila Ganjoo.
Because in this case, your lordship, there was no FIR, although. Instruction.
Yeah. After some time, Lordship will get the report. Perhaps it is there in our office.
Okay.
Whether any case is registered.
No case has been registered, and despite of that fact, the petitioner has been subjected harassment on the part of the police.
Acha, acha. We are trying to get the report. If
Okay, let
it is
them
at all-
get the report.
After some time. Okay. Oh. This is squashing of FIR.
Yes, and CDA and the case status has been called for in this case.
Case status and CDO.
Yes.
Wait. Wait, not that. Case record and status, CDN, status report as well. Our
Have you
intimate-
received?
Our intimation had gone on 5th of June, but we'll have to find it out. Let this matter also come up after some time.
Okay, let them find.
Oh, this is not received, I'm told. So,
Then we'll give you,
day after tomorrow?
what is the relief you are seeking?
Lordship, here, for the quashing of the name of the petitioner from the FIR, your lordship. Where his name has been wrongly implicated because in the FIR itself, your lordship, the name of the accused person is different, your lordship. But when the person has been arrested, it was the petitioner applicant hearing, your lordship.
You were arrested.
Yes, your lordship.
Now you are behind the bar or on bail.
Lordship, I am on enlarge on bail. More than 1.5 years has been passed, your lordship. There are,
Then we'll issue, notice has not been issued in this case.
yes, your lordship.
We'll issue notice.
Lordship.
Heard Miss, what is your name?
And Decca, your lordship.
Heard Miss N. Deka, learned counsel for the petitioner. Also heard Miss S. Jahan.
Notices was issued Nikki, on 20th of May.
No,
Of
no,
course, sir, it is written in my file.
No,
I don't know.
notice. was
Acha,
not
acha.
issued.
Okay. 20th of May 2024.
No, before issuing notice, perusal of the case diary was felt necessary.
Acha, acha. Okay. They were wrongly written perhaps by my learned friend.
This application has been filed under section 482 of the Code of Criminal Procedure from 1973 by the petitioner Nutya Chakma, praying for quashing of the FIR number 2141/2022, which was registered on 18/9/2022, on the basis of which Dispur PS case number. What is the Dispur PS case number?
2141, your lordship.
2141/2222 was registered. It appears from record that case diary of the said case was called for by the order dated 25/2024. However, same has not arrived. Learned additional public prosecutor has sought for some time for producing the case diary. Let the notice be issued to the respondents.
Nitya Chakma is the
Since-
victim here. Oh, acha.
Since the learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice by registered post with AD within 3 days from the date of this order, returnable on 19th, returnable on 18th July 2024. On the same day, learned additional public prosecutor is also requested to produce the case diary list accordingly.
Deeply obliged. Lordship has given what date in the previous matter?
18.
18th of July, Lordship. Item 14. Okay. Yeah. 14 is criminal petition,
Call after some time.
Lordship. Wait, Fakiravan's calling.
May I please the lordship, my lord? My lord, this criminal petition is filed under section 482, my lord. My lord, the prayer was, my lord, to allow the petitioner to appear before the trial court, my lord. The trial court, my lord, though it is a long pending, my lord, case, my lord, and I have annexed the entire order sheet, my lord. On several occasions, my lord, the summons was issued, my lord. And my lord, there is no report of the service of summon, my lord. And my lord, after that, my lord, suddenly the NBW issued, my lord. And my lord, this is against the provision of the section 82 of the CRPC, my lord. Then, my lord, proclamation also issued, my lord, after several dates of the NBW, my lord. So, my lord, the petitioners herein are the, my lord, in the CS, my lord, page number 23, 2, 3, and 4, my lord, page number 23. The petitioners in the charge sheet, my lord. In the charge sheet also, they were shown as absconder, my lord. But they were all along present in their, my lord, respective residence within the jurisdiction.
When the first non-bailable warrant of arrest was
Yes,
issued,
my lord. 8/3/16, page number 58, my lord. Page number 58. Accused are here, my lord, 8316, my lord, Hassan Ali, Sultan Ali, and Shohidul Ali. First order, my lord, and just before these dates, earlier order, my lord, page number 35. Before this NBW, my lord, the earlier order is 35, my lord, the last order, my lord,
Page number,
35, my lord.
what is there in page number 57?
My lord, these are, my lord, original vernacular. I have, my lord, translated copy, page number 35, my lord.
Yes.
After the translated copy, I have
35,
added the vernacular.
which order?
2216, my last order, my lord. 20 February 16, Fojibur absent the step by so and so, fix 8316 for NO, my lord.
Now, what are the names of petitioners?
Our name, my lord, Sultan Ali. My lord, it is mentioned in page number 35 itself, my lord, in the first row, my lord, page number 35. Order dated 2011-15. My lord, further, someone issued earlier to the accused, my lord, page number 35, first row, my lord. Further, someone issued earlier to the accused Hassan Ali, Sultan Ali, Shohidul Islam. These three, my lord, are the petitioners here in my lord. Hassan Ali, Sultan, Shohidul Islam. Shohidul Islam have been returned but not properly issued. For such issue, fresh summon issued. So, my lord, against the petitioner, fresh summon issued on this order is 2011-15, my lord. Next order, 24 December 15, my lord. The case is adjourned due to Assam bond. 8116, accused absent with step, fig, filed a petition so and so for appearance. 2216, my lord, these are other petitioners absent. Then, my lord, 8316, next page also, my lord, this order is there, my lord. 8316 is NBW order, my lord. Page number 36 is also, my lord, annexed, my lord. So the last issuing of the summon is page number 35, 2011-15, my lord, 20 November 15.
And when the first non-bailable warrant?
Yes, my
was
lord,
issued?
8316, my lord, page 36.
But then the order next to that, 5/5/2016 warrant of arrest is issued.
8316, my lord.
But after that, the next order warrant
Yes,
of
yes.
arrest is issued,
Yes, continue. Next continues, my lord, this NBW.
but then not non-bailable.
Yes. And then, my lord, page number 65, PNA issued, my lord, without following the procedure.
Vernacular to আছে নেই?
Vernacular was,
No, Mr. Kadir, my question is,
yes, yes.
on 26, 2016. No, on 2011-2015.
2011-2015, my lord.
At
Page
least
number 34,
35, 34.
Yes, sir.
The summons were issued to you.
Summons issued, yes, ma'am.
That was the last occasion.
Last issue, my lord, summon.
And thereafter?
Next, my lord, page
And
number.
Thereafter, on 8/3/2016,
Yes.
warrants were issued.
Yes, my lord, without any assigning any reason, my lord. There is
No, but
nothing.
have you reproduced the order properly?
Yes, my lord, I have all the order I brought, my lord, in the vernacular, my lord. Kindly, my lord, period.
Where is
I
it?
have not left any of the order, my lord. In the vernacular, my lord, I will show your lordship. Page number.
Okay, now what is your submission?
And
No, Ms. Jahan, his case is summons were issued without waiting for the
Any report?
report of the summons, he issued the, so they are not aware. He is claiming that summons were not properly served. There is no indication.
Mm. But then, of course, we'll have to go to each and every order with, it's difficult. Let him go and appear on the next day
yes, my lord, we will appear, my lord, on the next.
without fail. And if they do not,
Yes, ma'am.
then it will be cancelled.
Now, where is the last order?
Yes, my last order, my lord.
Fresh NBW to,
When is the next date fixed?
Yes, my lord.
25/6 again.
25/6 last order, my lord. I have the next number. Page number, my lord. 113, my lord. 113 is the, my lord, original copy, my lord.
There are lots of order. In between, never summon was issued.
No, they had
Nearby-
filed for bail application. They had filed for bail.
Bail, my lord?
Lordship will see 111.
Yes, lastly, my lord, November, my lord.
Hassan,
In November.
Sultan and Sahidul,
Yes,
bail was rejected.
in November, my lord.
Pre-arrest bail.
That is 438, yes.
So, my lord, next date on 25/6, my lord, this 25/6. So they will appear, my lord, and till then, my lord, then I will protect them. Page number 113, my lord. Accused, Fazul Islam is present, remaining co-accused are absent. Issue fresh notice to EO.
What is the offense?
My lord, offense under section, my lord, 120B, 353, 307, 429, 511, 25(1)A, read with 51 wildlife
Okay,
protection.
let
Act, my
them
lord.
appear.
So many.
Let them appear.
Let them appear on 25/6, I think is the.
Mr. M.J. Kadir, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely one Sultan Ali, number two Abdul Hussain alias Hassan Ali, number three Shahidul Islam, impugning the order dated 8/3/2016. Before that,
My lord, after that, my lord, PNA directly issued, my lord. PNA order is, my lord, page number 65.
no, Mr. Kadir,
Yes.
you are not,
Before that, yes, my lord, before that order, my lord, 22/16, my lord, page number 35.
no, don't confuse.
Rajiv
The
Rao.
first non-bailable warrant was issued.
8/3, my lord, 8/3. Page number 36. my lord. 8/3.
Not 8/3, it was 2011-2015. Oh, no, no.
Other,
Eight-
my lord, these are regarding other accused
Okay,
who are
okay,
present, who are, my lord,
okay.
arrested and present.
Impugning the order dated 8/3/2016 and subsequent orders passed by learned additional chief judicial magistrate Morigaon in GR case number 2260/2014, whereby non-bailable warrant of arrest were issued against the above named petitioner. Learned counsel for the petitioner has submitted that in the instant case, the charge sheet was laid against how many accused persons?
My lord, total 8 accused persons. my lord.
Against 8 accused persons, including the present petitioners. The name of the petitioners were shown
Page number
as absconder in the charge sheet. However, the trial court had issued summons to them. Learned counsel for the petitioner has submitted that on the last occasion when the summons were issued to the above named petitioners was on 2011-2015. However, thereafter, on 8/3/2016, without verifying due service of notice, due service of the summons issued to the present petitioner, learned additional chief judicial magistrate issued non-bailable warrant against the above named petitioner, and thereafter in due course also issued orders for proclaiming them as absconder and orders for attachment of their properties. Learned counsel for the petitioner has submitted that as no summons were served on the present petitioner, they were not aware about the pendency of the case against them before the Court of Learned Additional Public Prosecutor. And they are ready to operate in the trial and appear before the trial court on the next date fixed, that is on
my lord,
25/6.
25/6, tomorrow, my lord.
25/6/2024. So, learned additional public prosecutor also submits that the record shows that the,
In fact, there was report saying that it was unexecuted.
that without waiting for dues, without verifying the due service of summons on the above named petitioners, the
Report had come saying that it was not would not be executed.
the non-bailable warrant of arrest were issued as appears from the reports which are annexed along with the criminal petition. The court
But
on
report of unexecuted, Lordship can write that,
The-
page number 65, it's there.
the
Page
stop-
number 65.
on perusal of the records, it appears that the page number,
Page number 65, order dated 17/1/22. That NBW issued against so-and-so have returned unexecuted with report.
okay, no.
They are
but Before
deliberately
issuing NBWA,
before issuing it.
okay. No. No, me line to cut. The trial court ought to have ensured due service of notice, service of summons issued to the petitioners before issuing non-bailable warrant to them. So, under such circumstances, this court disposes of this criminal petition with a directions to the petitioners, above named petitioners, to appear before the trial court on the next date fixed, that is on 25/6/2024. And to facilitate such an appearance before the trial court, the operation of non-bailable warrant of arrest issued against the present petitioner, above named petitioner, shall remain suspended till that day.
And my lord, subsequently PNA also issued, my lord, that also be my lord.
PNA was,
Also issued, my lord, on 17/1/22, my lord. Page number 65, my lord.
and the no, but it was not executed,
Not executed, yes.
so it does not matter.
Obliged.
So, on his appearance before the learned additional chief judicial magistrate, the petitioner may pray for any relief to which he is legally entitled to. With the above observation, this criminal petition is disposed of.
Obliged. My lord, the order for the made available today, my lord. Tomorrow is the
You will
day.
get it today itself.
Okay, hi, lord.
I'm extremely sorry, Your Lordship. Lordship, in item number 11, I was in legs. Lordship, I humbly pray this matter may be taken up as the last item in the list, Lordship.
Okay.
I'm
You
deeply
are,
obliged.
you are taking a risk.
Lordship,
Okay, no, your prayer is allowed. We'll take it up.
that's the last item, Lordship. I'm deeply obliged, Lordship.
Lordship,
Oh, is it? We have already passed an order.
Lordship. Lordship, I was in legs, Lordship, that's why I could not.
Okay. We to cancel. I mean, we'll take it up.
Lordship.
Lordship, I'm also sorry, Lordship. Item number 14, Lordship. I was in court number 4, Lordship.
14.
14. 1 4.
Acha, 14 was passed over for the time being.
Timing.
Yes.
May I, your Lordship? Lordship, in this case, Lordship, what happened, Lordship? The opposite party number 2, Lordship, has taken an amount of rupees 42 lakhs from the petitioner, Lordship, by executing a Panama, Lordship, to sell a plot of land, Lordship. I have attached the Panama, Lordship, page 15, Lordship. This is the translated copy and vernacular is page 17, Lordship. By executing, Lordship, this Panama, Lordship, he has first taken, Lordship, 21 lakhs 50,000, Lordship. And then, Lordship, but we have to receive, Lordship, I have annexed lordship, page 19. He has taken 10 lakhs, page lordship. And that lordship he has taken total 42 lakhs. Thereafter, lordship, when the process for the petitioner approaching him to start the process of lordship as executing the sale deed lordship, he has started lordship, lordship taking time and not giving the appropriate lordship process lordship. Then petitioner demanded him, the lordship, to return back the money lordship. Then lordship, the opposite party number 2 lordship, given lordship him 30 lakhs lordship by issuing some checks lordship. I have annexed these checks lordship. Page 21 lordship, page 22, page 23, page 24 lordship. And when the petitioner lordship deposited these checks lordship, these checks lordship dishonored lordship by the respective bank lordship. I have also annexed the report of dishonor lordship, page annexure 4, page 25, 26, 27, 28, 29, 30 lordship. Thereafter, lordship, petitioner issued lordship, send him lordship 2 legal notice lordship, page 33 lordship, page 33, page 35. And after receiving lordship this notice lordship, the petitioner lordship filed a case against FIR lordship against the opposite party number 2.
Where is the FIR?
This is lordship, page 37. The
What is-
petitioner lodged FIR lordship against opposite party. This is the FIR. page 37.
You lost.
Yes, lordship.
Okay, thereafter.
And thereafter, lordship, page 40, the opposite party lodged FIR lordship against the petitioner, page 40. And he says that lordship, these checks were lordship issued lordship only to the petitioner lordship, and this is the humble statement is that the accused person in the name of providing loan from the state bank has taken 7 blank checks, etc. lordship. This is the allegation.
Now,
And subsequently, lordship, the police submitted charge sheet lordship, page lordship,
charge sheet in this case,
Yes,
the
lordship.
FIR lost by the
by the
opposite.
opposite party.
Okay,
Opposite party. And lordship, kindly see lordship, the during the pendency of this investigation, lordship, petitioner took lordship, anticipated the main lordship, appeared the police and submitted all these documents and stated all these things, lordship. And
now what is your prayer?
my prayer is that lordship, the petitioner also filed NIA case against the opposite party. This is also pending, lordship. I have annexed page 55, 56, 57. Then lordship, petitioner filed title suit for specific performance, lordship. And in the title suit, lordship, the respondent number 2 also submitted his W as lordship. I have also annexed, lordship. So my lord, this entire thing is lordship. Matter is civil nature, lordship. The pendency of this criminal proceeding is lordship. Just abuse of the process of law, lordship. This matter may be lordship. The opposite party lordship has taken lordship. The process lordship only to harass the petitioner.
Okay, we are issuing notice.
And
Ingredients of 420 and 506 are there in the FIR.
In his FIR, from the very beginning. We are issuing notice and calling for the scan copy.
lordship, till then lordship, the proceeding may be stayed and.
No. How, Mr.
MS Majumdar.
Yeah,
Lordship, in
MS
the meantime, lordship, the opposite party also comes for lordship compromise. This is the he himself,
No, if
lordship,
there is a settlement, it is well
Yes.
and good.
page 61, lordship. He has lordship both.
Mr. AMS Majumdar, learned counsel for the petitioner. Also, Ms. S. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973. Read with Article 227 of the Constitution of India, has been filed by the petitioner Karim Uddin Ahmed, alias Muhammad Karim Uddin, praying for washing of PRC case number 197/224, arising out of the FIR, which was lodged by respondent number 2 against the petitioner, alleging commission of offense under section 420/506 of the Indian Penal Code. Issue notice to the respondents, since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued. As regards the respondent number 2, the petitioner shall take steps for issuance of notice to respondent number 2 by registered post with ID returnable on 24th July. Stop. Let also the scanned copy of the case record of PRC case number
197.
197/2024, along with scanned copy of the case diary of the Belzar PS case number 216/2024-22 be called for from the Court of London Chief Judicial Magistrate number list accordingly.
My lord, till then, lordship. There is I have NS lordship. He has also.
No,
said-
let him appear.
Then he did not worry at all if
No, no.
there is a compromise.
No,
thing
no,
going
he executed a compromise deed,
Let the other
but
side.
he himself not acted on that lordship. Thereafter, title switch filed and he also appeared in the title switch.
Okay, let the other side appear.
lordship.
16, I think on the last occasion, Lordship wanted us to find out whether case was registered.
case.
Rare case was
Whether a case
registered.
was registered or not, a report was solved for.
I'm trying to find out. Lordship will take it up after some time. To Gloria.
Can it be a 2, my lord?
Two.
The instruction, madam.
Okay.
Whether it
What
is
will
registered.
happen if no case is filed? It will become infructuous.
Yes.
No, in fact, if we can show that, that of course there is a case which is pending, it is lodged, not registered, lodged. I think he can still get some bail, some
Actually, my
protection.
lord, because on multiple occasions, my lord, the police officials from the Bilasipara police station asked the petitioner to appear there. Multiple occasions. I have even noted the phone numbers, my lord. So that is why, my lord, we are under an impression that perhaps, my lord, a case may have been registered.
Okay, let them find out.
Lodged,
Right.
at 2.
Highly occasional.
May I please your lordship? Lordship, 430 replication, your lordship. Your lordship, the FIR has been registered under section 1911 of the Prohibition of Child Welfare and 6 and 17 of the POCSO Act, your lordship. But here, your lordship, I missed two relevant documents.
My lord, this is a 438 application by the petitioner. In respect of an FIR, lordship, as back as of 2020, lordship, 13, 14, and XR4, with page 16 is the FIR. Lordship, the petitioner before your lordship is not a named accused. And in fact, the
FIR is that page?
page 16, lordship, and XR4.
Morning, sir.
16, the translated copy, lordship.
Morning, sir.
And in
What is
Good
the
morning, sir.
accusation allegation?
lordship, the allegation is that
Snigdha Das.
the informant had informed that two persons, accused number 1 and 2, asked him to deliver possession in view of the fact that accused number 3 has already taken some amount from the purchaser accused number 4 as advance of his land, informant's land, lordship. And lordship, your lordship will find it at page 17. 1, 2 demanded possession in view of the fact, lordship, that his land was proposed to be sold or agreement for sale was there for 15.5 lakhs, lordship. Thereafter, 4.3 lakhs was taken by the accused number 3. Entire modus operandi or the role played by the accused has been reflected, lordship. Accused number
Land belong to the informant.
informant, lordship, he said, but it was not sold. It was not sold. Whatever it be, lordship, I am a practicing advocate in the bar, and lordship,
You are an advocate.
advocate lordship at the Bishanath Sari Alibag.
How you
Let it-
got
Lordship,
involved?
at the initial stage, lordship will find I was told, and I cooperated with the investigating officer lordship. And what happened at that point of time? No document except an affidavit lordship back to the photocopy. And in the photocopy lordship, the signature, what I found is that it is not my signature truly. This time lordship, the apprehension before the of the petitioner before your lordship is that now recently they have again called you, stating that your signature resembles to that as per forensic laboratory after 4 years lordship.
Where? Your signatures are there on,
That
On
has
the
not
land documents, I think.
on the land documents.
lordship. They say resembles. So at this lordship, I have filed one FIR that my signature may be forced also because
You
the
file an FIR.
lordship.
Where is the FIR?
Lordship is at page 27, that is annexure 8 lordship. Now I have been told, yet I have not been shown the original that way. Stating that after 4 years lordship of the FIR, being an advocate, and I have no scope to go out lordship anywhere. I am a lady of 50s, in 50s.
Now what will you do?
Lordship. But my
Will it-
prayer is before your lordship is that because of calling, he is by the police now. The advocate is little bit apprehensive of that she may somewhere or sometime may be disturbed by police or may arrest even. Because lordship, that is the reason why I have come before your lordship for taking.
Now will you go to the IO, before the IO?
Yes, lordship, I have been going.
You are ready to.
Yes,
prepare.
lordship, ready, and I have
Let-
been going. I have been going, lordship. My statement is there. Whenever I was called lordship at the very initial stage.
Okay, heard Mr. L. Talukdar, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure has been filed by the petitioner Snigdha Das alias Snigdha Chaudhary, who is apprehending her arrest in connection with Bishwanath Charali PS case number 148/2020 under section 420/419/423/468/471 of the Indian Penal Code. The gist of accusation in this case is that one, Santosh Sapkota had lodged an FIR on 13/6/2020 before the officer in charge of Bishwanath Sarali Police Station, naming 4 accused in the said FIR, inter alia, alleging that the informant is the owner of a plot of 1 bigha of land covered by Dag number 222 under KP Patta number 47 in village Kodomani. However, he came to know that accused number P named in the FIR had fraudulently sold.
Not sold, lordship. The
Agree.
FIR transpires that fixing 15.5 lakhs consideration, they have taken 4.3 lakhs.
There was an agreement to sell.
Maybe lordship, that is not there. However, the informant has in fact discovered or rather found everything and he has reflected in his, without naming me, lordship.
Okay. So
What is written is they have purchased a plot of land.
sold actually.
It cannot be. They have taken only, maybe.
No, but that is the allegation. Sold the said land and
এটা যেটা লিখেছে
and on 11/6/2020, they came there to take and demanded the possession of the said plot of land. Learned counsel for the petitioner has submitted that the petitioner is a practicing advocate by profession, and she was earlier called by the investigating officer in the year 2020 when she cooperated in the investigation, and her statement was also recorded. However, again, recently she has recently she has been again contacted by the investigating officer, who informed him that the signatures in the land document in the documents of the case resembles her signature. Stop. Learned counsel for the petitioner submits that the petitioner has never affixed her signature in any of such document as stated by the IO, and therefore on 16/6/2024 she had lodged an FIR before the officer in charge of Bishwanath Sarali Police Station, alleging forgery of her signature in the affidavit. Learned counsel for the petitioner has submitted that this is a old pending case of the year 2020, where the petitioner had cooperated in the investigation. However, now she apprehends that if she appears before the police, she may be arrested. It is also submitted that the petitioner is ready to cooperate in the investigation. What is to be done? Dispose of,
That is what I'm saying to my learned friend.
instead of calling.
Disposed of lordship, since he is cooperating.
Okay.
If she does not cooperate, then
We are also lordship. In course, you are shocked today.
Considering the submissions made by learned counsel for the petitioners, learned counsel for the petitioner as well as the learned additional public prosecutor, as well as considering the documents annexed along with the
Petition.
bail application. This court is of considered opinion that if the petitioner cooperates in the investigation, her custodial interrogation may not be necessary for fair completion of the investigation in Bishwanath Sarali PS case number 148/2020. In stop. In view of above, the above named petitioner is directed to appear before the investigating officer of Bishwanath Sarali PS case number 148/2020 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If she does so within the stipulated period of time, in the event of her arrest in connection with Bishwanath Sarali PS case number 148/2020, the above named petitioner shall be granted bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Condition number 1 and 2. With above observation, this anticipatory bail application is disposed of.
That's deeply obliged.
He will cooperate in investigations. That is the,
For last 4 years, I have been doing so.
that is the only.
I am an advocate, lordship, a responsible advocate, so she knows lordship in that she has been cooperating.
Okay.
Deeply obliged, lordship.
question কৰিব চাগে।
Lovely condition.
The FIR lordship will find on page 8 lordship.
Yes.
The third party has lodged an FIR lordship.
What is the,
May I read the FIR lordship?
এনেও ওলাব পাৰে।
yes,
I have the honor to state that on 28/5/2024 at about so I was standing over the Pakka Bridge situated at southern side of the Tengu Bridge Market. The accused, namely Wasim Guljar Arif and 3-4 others, obstructed the Ohidur Rahman who was riding the bike and pillow rider Habar Ali. The accused Guljar assaulted Ohidur Rahman with umbrella, Wasim and Arif assaulted with bamboo and taken away the bike and his marketing bag. I have seen the same. After half an hour, I have seen the vehicle of OC sir crossing the bridge. While OC sir is returning back to the bridge, he stopped the vehicle there. I heard that some.
What
drugs-
is your name?
We are three Lordship of Wasim Guljar Arif.
All three have come,
All three,
All
three are
brothers,
registered.
own brothers Lordship.
They have
The
to-
person is a
but there are specific allegations against.
peddler Lordship, so they have fought, but bike they have not stolen. They have categorically stated in the petition. He fled away Lordship, keeping the bike on the bridge Lordship. It was recovered from there itself.
Criminal antecedents are also there.
Kindly
Let
Lordship.
the CD come on.
CD.
He definitely CD. Look, think and Lordship, kindly some into more. Possible kindly see, there is 384 does not count, 383 does not attract Lordship and 325 is available. Other
Why 383 does not come?
because he doesn't say anything about the demand and all extortion part Lordship. In CD, Sijal it will come Lordship, not a whisper against the bike. The bike was their Lordship. He was a peddler Lordship only because of that.
28.
Lordship.
We'll fix it on 28.
28.
But kindly till then Lordship.
No,
28
So
is just
absolutely
coming.
Lordship will kindly see no allegation
You
regarding
try
the
to
section has been
no, why should you be given if you are not innocent?
No. If bike would not been their Lordship, then 379 would been added by the police Lordship regarding the bike.
No, where did the bike go? Where it is? We don't know. Only the
379 would been definitely there.
Heard, Mr.
379 is not there Lordship in the.
We are fixing a short date.
28 Lordship, possibly it will not come Lordship.
27.
Kindly Lordship, kindly until till then Lordship.
If it
Three
does
own
not,
brothers Lordship. They are not friends Lordship. Lordship will kindly see the cost title Lordship. Cost title Lordship will kindly see all our brothers Lordship. Own
No.
brother Lordship.
but you have been specifically named.
We
Specific
definitely,
allegation.
that FIR has been lost by third person Lordship, not by the victim himself Lordship.
Maybe.
And the
anybody can
allegation
lodge
is
a
regarding drug
No,
Lordship.
victim is the accused here.
no.
Wahidur Rahman, I mean, drugs were planted in his bag. So he is
No,
an.
planted fully could have.
No, I mean, I heard that some drugs are found in the bag
Bag
of.
of Ohidur Rahman. Ohidur Rahman is the victim.
Wahidur Rahman
Rahman
is the victim.
Therefore, for that thing, he was caught Lordship. For he being as a peddler Lordship, he was caught Lordship.
So where is the victim? There is no victim here.
Ohidur Rahman is the victim.
But then he became a subsequently accused perhaps for.
The third person has lost the FIR. The interested party has lost the FIR Lordship. Absolutely no allegation has been made out regarding the 326 Lordship, 325 Lordship has been registered. Kindly Lordship till then Lordship,
What is it? Who is Arif?
Arif is brother Lordship. That part has been added because of that he is a
No,
peddler
no.
Lordship.
Nothing is clear from here.
That
And
third
the
party-
rejection order is there. Lordship will see at page 18. They have moved AB before the law court.
After perusal of the case study,
I don't know that accused.
It simply says material Lordship, not what specific material, nothing has been mentioned Lordship.
but
Last part Lordship will see your page
Case
19.
diary, yes, case
Page
after
19,
perusal of.
Lordship will kindly see.
after perusal of the.
No, that the
Ah.
case diary contains the injury of Wahidur Rahman showing the injury simple. And the statement of witnesses and victim are recorded considering the material against the accused prisoner, prayer for bail is rejected Lord. Nothing specific Lordship, only saying that the material Lordship. And the witnesses means he is the interested witness Lordship, we have lost the FIR. The victim neither lost the FIR Lordship because they have no point of lodging a FIR Lordship without the fault of that petitioner Lordship.
Heard Mr. S. Lunid, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. Since the petitioner's anticipatory bail application was earlier rejected by learned Sessions Judge Morigaon. And that for consideration of the instant bail, anticipatory bail application, perusal of the case diary would be necessary, hence call for the case diary. 28 or after vacation.
But I think it will not reach, Lordship. It will come in bail hearing and last day, motion will be.
Then let us fix it after vacation.
Let us try, Lordship, 28th. If no interim, Lordship.
On 28, 26
Lord.
for case.
Lordship. Much obliged, your Lordship. Much obliged. Much obliged.
A probable case again.
Lordships, yes. 430 application Lordships,
No FIR is there.
yes, Lordships. So report may be called for Lordships. Dispute between husband and wife Lordships, she left the house of the petitioner. My lord, and on that day when she left the house of the petitioner, the police came to the residence of the petitioner Lordships. The police is frequently calling him Lordships.
Phone
Uh,
দিয়েছে?
No,
Heard Mr. M. Hawk, learned counsel for the petitioner. Also heard Miss S. Jahan, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure has been filed by the petitioner Rajat Ali
alias Abdul Razak.
alias Abdul Razak, who is apprehending that he may be arrested in connection with a case which might have been lodged by his wife Ritumani Begum. Staff learned counsel for the petitioner has submitted that when the wife has left
On 9/6 Lordships, 9/6.
9/6/2024, the wife of the petitioner had left for her maternal home and thereafter
On the same day,
on the same day, the police of Mongol
Night crossing.
police station visited the residence of the petitioner is searching for him. However, he is not aware about any pending case against him in Mongolder police station. You have inquired from Mongolder police station.
Lordships. Police is calling me Lordship. Even Gaura, the police also called the Gaura also Lordships. So that the Gaura handed over me. But Lordships, I have the apprehension that if I appear before the police Lordships, I may be arrested Lordships. So my lord,
I'll get the instruction.
So, as no pending case, as no details of any pending case has been mentioned by the petitioner in his bail application, the public prosecutor is requested to get information from the officer in charge of Mongolder police station as to whether any criminal case is pending against the present petitioner, namely Abdul Razzaq alias Razzaq Ali in the said police station. When will you bring?
Day after tomorrow, any day, we'll have a telephonic conversation.
Let this case be listed again on 26th June.
Lodge.
and development.
খবর হলে।
May I please?
Yes.
Lordship, the respondent number 2, who is the daughter-in-law of present petitioners, filed a complaint case under section 12 of the Protection of Women from Domestic Violence Act 2005 before the learned Chief Judicial Magistrate. And learned Chief Judicial Magistrate first class on 22/5/2024 take cognizance against the present petitioners. And issue notice to-
Matrimonial issue, let the notice go now.
Lastly, there is no any domestic relationship with the present.
Admission to site করে দিন।
Lordship, this matter may be fixed at 2 Lordship, along with 59 Lordship.
Same case.
I'm 59, I'm for 59.
Okay.
Highly organized.
But please, your lordship, 439 application lordship. Petitioner was arrested on 22/7/2023. And in this case, charge sheet was submitted. The scan copy and status report was called for, but it was received in the month of April, lordship. Present status, I have no idea about this.
What is to be done?
Up to date status report may be called for, lordship.
No,
As
to
per
my
the,
information, no evidence. yet to be-
Till now, no witness examined.
No witnesses
Total
examined.
witness 7.
Charge frame on 9/2/2024.
We'll call and updated. Status report is updated up to
Up to April also.
Up to April 23/4/24. Next date was 23/4/24.
heard Miss S.K. Nargis, learned counsel for the petitioner. Also heard Miss N. Das, learned additional public prosecutor. It is submitted at bar that the scan copy of the case record of NDPS case number 4/2024, which was called for in connection with this case, reveals that same is updated only till the month of April 2024. Though learned counsel for the petitioner has submitted that till today, no witness has been examined. However, this court deems it proper to call for an updated status report as on date as regards the number of witnesses examined by the petitioner, by the trial court in the said case. Hence, call for an updated status report as regarding the status of NDPS case number 4/2024 and the number of witnesses already examined, number of prosecution witnesses already examined in the said case. Let this case be listed again.
The first week of August or later because it's from July, the depot.
First week of August. On 2nd August.
Obliged.
Made with your lordship. Lordship 439 application lordship. The matter pertains to my lord commercial quantity under the NDPS Act. On earlier occasion, my lord, because the LCR which was received was of the month of February, this court was of the opinion as to call for the updated case, the status report, and my lord number of witnesses examined. I also in the meantime have obtained my lord certified copies. It appears that since my lord May 2023, my lord, PW1 has not been completed examining. More than 1 year, 2 months, my lord. I have been behind bars for 2 years, 1 month and 6 days, my lord. I believe the.
When were you arrested?
My lord, I was arrested on 19/5/2022, my lord. 19/5/2022, my lord. My lord, annexure 2, page number 18 is my arrest memo, my lord.
What was the seized contraband?
My lord, the seized contraband, my lord, would be reflected at page number 20, my lord. That is ganja, my lord.
How much?
My lord, 530 kg allegedly, my lord. There is some discrepancy in the seizure as to at the place of my lord interception. the seizure
Against
was
how
not-
many persons the
My lord,
charge sheet was?
These 2 persons, my lord.
Both are the petitioners.
Yes, my lord. Charge sheet, my lord, was laid on 19/11/2022, my lord. Charges were framed on 18th of May, my lord, 18/5/23, my lord. And since then, till date, my lord, 28th of June this year, my lord, 1 witness has not yet been completed, my lord.
How many witnesses are there?
My lord, there are, I believe, 11 witnesses enumerated in the charge sheet, my lord. And 1 has not yet been completed, my lord, in 13 months.
Lordship, one pair, Lordship, this matter may be fixed at 2 along with other matters.
Earlier occasion also the short time, my lord.
Other matters are, why? This is not related to the matters which,
Lordship, my senior is an next in another pair, Lordship.
no similar matters are coming up where NCB is there and there is huge delay in all cases. Here. Okay, we'll take it up at two. No. What is the submission?
Lordship,
Your senior will make some.
yes, Lordship.
Okay, we'll take it up to.
As your lordship pleases, my lord.
Highly obliged.
May it please your lordship. This matter.
Lordship, same pair, Lordship.
Let her senior come.
Mr. Trial is always busy in other
No,
courts.
I'm accommodating him. Let him comment too. We'll take it.
I'm not against that. My learned friend.
Because here also how
I-
long you are behind the bars?
I am about 3.
3 years.
3 years, and charge sheet was submitted, your lordship, way back on 2020,
Okay,
28,
at 2
12,
we'll
21.
serially take NCB matters. At 2.
It's okay, I have no problem. There's another item, 50,
58, Lordship.
58, that also may be taken up.
Same ground.
We are taking mostly the same ground, and again, NCB is there. Ultimately, again, she will take time. So that also may be at 2 o'clock.
Okay.
Much better.
Highly obliged. May it please your lordship, 439 of CRPC, and the sections are raised at 420 and 406. Today completed 52 days in custody. And the FIR is page number 8. I submitted that I reside at IS Colony, Khanapara. My friend, Sikandrajit Boro, told me that to
FIR
participate
is at page number?
8.
Okay. What is the?
To purchase a bike in your name by giving your documents, the same will be given to an agency. The agency will apply the bike by completing the EMI in 3 months. You will be given 30,000, and they will also give the down payment. By saying that he introduced me one of his friend, namely Rajesh Nath, alias Rishi. Accordingly, I had given my Aadhaar, PAN card and bank account. Thereafter, they purchased the bike on 25 October by paying down payment of rupees 50,000 and left, and they gave me rupees 3,000. But till today, they have not given the EMI. I was
Compelled.
compelled to pay the EMI, and when I called Rajesh Nath, I found his phone to be switched off. And I am not a Rajesh Nath. We are not a Sikandrajit, and we are
What is your name?
Kilwar Ali, and number 2.
You are not
is-
named in the FIR.
Yes, Lordship.
Then why were you, this is anticipated, available. Since when you are behind the bars? Date of arrest?
3/5/24.
Yes, Mr. Kaushik.
No, not actually what has happened, they are running a racket. This person who has been named in the FIR, Rajesh, he will lure innocent boys, asking them to provide their Aadhaar and other documents. He will tell them that they are running an agency where they will receive their bikes and they will pay them monthly 2,000 rupees, and they will also pay the EMI. Believing him, my lord, few boys, my lord, this is one case, my lord. During the investigation, it has been found that more than 60 bikes has been handed over like that, and several cases are pending in other PS also. That this then he will receive the document from the victim. He will go to the dealer with the victim. They will receive the bike, then he will take the bike away, and he will promise the victim that he will pay the EMI along with monthly 2,000, and he is running an agency. Believing that, my lord, some people handed over their document. During investigation, my lord, this Rajesh was arrested And while in investigation, further investigation, police came to know that this Rajesh will, after receiving the bike, will hand over to one Tofikul Rahman, which is a petitioner of item number 31. And this Tofikul Rahman then hand over this to the Kilwar Ali and my lord, this Taijul,
Page number 18 and page number,
Taijul Islam,
page
my
number
lord.
20 is the Caesar list, your lordship.
Taijul Islam, let me separate. Taijul
Page
Islam.
number 18
No,
is the
let-
Caesar list.
let-
There have no articles recovered from us, your lord.
Let him submit.
Then
You
it will,
you may reply.
it will hand over to Taijul Islam. Then they further hand it over to 3 people of Meghalaya. Then they will sell these bikes to and other vehicles in Bangladesh. So there is a organized racket running. A main culprit is this Rajesh and this my lord Taijul and Kilwar and this my lord yes Taijul and petitioner item number 31 Tofikul. They are running a syndicate, my lord. In fact, similar cases were registered in Sonapur and Dispur PS also, and one victim also committed suicide. Because their documents are before the dealer, before the finance company, and finance company are now pressurizing them for paying EMI. And these victims belongs to a poor family, my lord.
But so there are materials against them.
Sufficient materials against them.
No, lordship.
And some people, 3 persons who ultimately sells those bikes in different part of Meghalaya and Bangladesh, they are on the run. Police are searching them, my lord.
No, but in this case,
Yes, my lord.
there is allegation by Vivek Chetri only. Of luring one Tikendrajit Boro.
Yes.
Page number 18 is the Caesar list, your lordship. There have no articles recovered from the accused persons, your lordship. Kliwar Ali, which is related in this matter, your lordship. And the page number
Now,
20 is
the
the Caesar.
bike in this, which was purchased in this case has been recovered.
No, my lord, because that has already been disposed of. They ultimately, they sales those bikes. This is one of the bike. They sales those bike in Bangladesh and Meghalaya. My lord. And that has been done through 3 other persons.
No.
Those are, I don't want to disclose their name because it is under investigation. Those are on the run.
Lordship, one is the main accused person, Rajesh Nath. He has already granted bail.
Where is the bail order? Rajesh bail order.
Yes, lordship, Rajesh Nath already granted.
Where is the bail order?
Bail order.
I am item number 31, your lordship. In this case, your lordship, main accused Rajesh Nath has already been bailed, your lordship. GMFC, your lordship, Kamrup Metro.
No, give it to PP.
All the allegation, your lordship, in this case, your lordship, FIR is
Ekbar.
clearly stated, your lordship. Your lordship.
No, I am not hearing 31 now.
Yes.
Mr. Kaushik, considering the fact that the co-accused has been, who has granted the bail to co-accused, this court or the?
And a court below, my lord.
On what ground?
What is default bill?
Or default bail?
Default bill. That they
And-
cannot claim.
No, default bail, and these present petitioners have also completed 52 days.
Yes, lordship.
Yes, my lord.
So after 8 days, they will ultimately get default bail. Now, do you need their
Because
custodial?
so
detention?
far, the CD reveals, my lord, their interrogation is going on several locations, my lord. And 3 people are on the run still. Because why, my lord, when Rajesh Das was arrested, then my lord, these
Default
people,
bail.
these people were arrested subsequently.
But in this case, your lordship, sections are registered only 420 and 406 of IPC. Which is the allegation made against by us by the Linet ABP. These sections are not arise in this case, your lordship. And the 420 and 406 of the IPC, 60 days is statutory period. And we have completed today 52 days in custody.
Heard, Miss. This is item number
30.
31 is also similar, my lord.
heard Miss A. Medhi, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Kiluvar Ali alias Kilwar Ali alias Kilu and Taizul Islam alias Taizul Islam, who are detained behind the bars since 3/5/2024 within bracket for last 52 days in connection with Gitanagar PS case number 321/2023 under section 420/406/34 of the Indian Penal Code. The gist of accusation in this case is that on 7/12/2023, one Vivek Chetri had lodged an FIR before the officer in charge of Gitanagar Police Station, inter alia, alleging that one of the friend of the first informant, namely Tikendrajit Boro, had informed him that informed had asked him to had introduced him to one Rajesh Nath alias Rishi, with informing him that if he gives his documents to the said Rajesh Nath, his agency will purchase a bike in his name by paying the down payment of rupees 30,000 and also by paying the EMI in 3 months. Accordingly, the informant gave his Aadhaar card, PAN card and bank account number, bank documents. It is also alleged in the FIR that thereafter the said Rajesh Nath and his accomplice purchased a bike on 25th October by paying the down payment of rupees 50,000 and left along with the bike, and only 3,000 was paid to the first informant. It is also alleged that neither the bike was handed over nor any EMI was paid against the said loan. And when the first informant tried to contact the said Rajesh Nath, he was found to be switched off. The counsel for the petitioner has submitted that nothing was seized from the possession of the present petitioners. and they are not involved in the offence alleged in the said FIR. It is also submitted by learned counsel for the petitioner that the offence involved in this case is under section 406/420 of the Indian Penal Code, for which the maximum statutory period for detention is 60 days only. And the above named petitioners have already completed 52 days behind the bars. It is also submitted by learned counsel for the petitioner that in the meanwhile, Rajesh Nath alias Rishi, who was also apprehended in connection with this case, has already been granted it is not default bail.
Found what default name?
Putul. Granted bail by the learned trial court.
Yes, I'm sorry, in default.
Yes. On the other hand, learned additional public prosecutor has submitted that the petitioners are involved in there are materials in the case diary against the present petitioners. And they are members of a racket who indulge in similar activity of duping the innocent poor people of their hard-earned money. It is submitted by learned counsel for the petitioner that similar other cases are pending where 60,
My lord, submitted by me.
yes, sorry, learned additional public prosecutor. Not petitioner. Learned additional public prosecutor that similar other cases were filed and the modus operandi of the offenders are to dupe the innocent persons and then purchase the bikes out of the loan amount procured from in their name and thereafter selling the said bikes in Bangladesh.
Different parts of Northeast and Bangladesh.
Different parts of Northeast as well as Bangladesh. He has submitted that in the case, the investigation of this case is still going on and some of the co-accused are yet to be arrested. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of Gitanagar PS case number 321/2023. Though there are some materials against the present petitioners in the case diary, however, considering the fact that the main accused of this case, that one of the main accused of this case, namely Rajesh Nath alias Rishi, has already been granted bail. Moreover, considering the progress made in the investigation and as well as the period of detention already undergone by the petitioners, this court is of considered opinion that further custodial detention of the above named petitioners may not be necessary if they cooperate in the investigation. In view of above, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount to the satisfaction of learned Chief Judicial Magistrate, Guwahati Metro, with following conditions. Condition number 1 and 2. Send back the case diary. This bail application is accordingly disposed of. The connected inter. What is this IF for?
I'm for
Dispose.
Tilwar Ali and Taijul Islam.
Okay. Disposal.
March August.
31 is same.
May I please, your lordship. Similar affair, your lordship. I am appearing, your lordship, Tawfiqul Rahman,
Similar or same?
same. Fire, same affair, your lordship.
Same affair.
Same, your lordship. 56 days behind the bar, your lordship. Tawfiqul Rahman, arrest on your lordship 29/4/2024. So lordship.
Here also Rajesh is there.
Rajesh is there, your lordship.
Same order. Petitioner naam halai debo. And date of detention. When were you arrested? Date of
29/4/2024. 56 days as on today,
29/4,
2024.
date of arrest and 56 days. Change hoga. Baki ke 30. You are also 30,000 with one city.
Obliged.
But the idea has been called.
CD not received, my lord. And service, CD not happened.
When will you bring the case diary?
Mati. Friday,
Well,
but service, whether complete or not, my lord, POCSO case.
No, this you have to ensure from the. Yeah, it says that they have taken steps. Through registered posts. But not through.
It should be through registry.
No. There are specific directions that it should be in terms of notification number 17.
Yeah.
You have to take steps for.
Out of same FIR and the CD has obtained, you know that.
Well, the present case is Hatigaon PS case number 8624.
What is your case number?
Same case. FIR
No,
number
you-
is same.
Hatigaon PS case 86.
Yes, your lordship. Yes. Article PS case number. Accused is separate.
Now what is to be done? Your case is not before us.
Then all the cases may be taken up in some other date, day after tomorrow.
Lordship.
But it may be taken up at 2, lordship.
2 it will be difficult again.
Now protection list the same. Causes. Okay, we'll take it after in the second half, not at
Lordship.
second half.
Highly obliged.
Obliged.
May I please, your lordship. Herein the petitioner for 41 days is in custody, your lordship. He was arrested on 14/5/2024. Case 12 is the FIR, your lordship. Herein the allegation is against one company that the company had taken away.
Where is the affair?
Case 12.
Yes, what is the allegation?
basically the allegation is against one ANLP company, Your Lordship. And it has alleged that the company had taken away 80% of the materials of a bridge. And the present petitioner, he was the labor, he worked under the instruction of the said company, Your Lordship. And the name of the petitioner is also not mentioned in the FIR. Which does it mean?
Lordship, materials are there, Lordship, against the petitioner. He's the driver of the crane, Lordship. And
Driver of the crane.
yes, Lordship, and he's also involved with the other co-accused, Lordship. And Lordship, one bail objection is there that Lordship co-accused person involved in the crime are yet to be apprehended and arrested, and there also be less possibility to recover the stolen government properties and the abandoned old iron bridge spaces at about scraps at about 5 to 6 loaded trucks were involved in loading and delivering the abandoned iron bridge scraps valued approximately 40 lakhs. The accused person was involved in commission of the crime to cut the old iron bridge within short amount of time with help of hydraulic crane, and the abandoned iron bridge scraps were transported from the spot to an unknown destination.
But herein, Your Lordship, the petitioner, he was engaged by one Omar Farooq Ahmed.
His statement is also available,
Yes.
Lordship, Jahidul Islam
No,
statement.
but you are engaged for a wrong illegal act.
No,
And he
I
was
engaged by him.
aware of, Lordship.
I was engaged by him. I was engaged by one Omar Farooq Akon. And I was the labor, and I was operating the hydraulic machine.
Lordship, in his statement.
I was
is
operating the
available,
hydraulic
Lordship.
machine, but I was engaged by the employee of the company, Your Lordship.
Then what? What is your defense? Suppose you are engaged to commit a murder by somebody.
No, we are labor, Your Lordship. I am not on that point, Your Lordship. 40
Their
days, Your
their
Lordship.
allegation is that an offense of theft of a bridge has been committed. And your defense is that you were involved, but you were engaged by somebody else. That
He is
cannot be
aware,
a defense.
Lordship, I am for 41 days, Your Lordship. I have been thoroughly interrogated, Your Lordship. 41 days, I am behind the bar, Your Lordship. I think the further custody, Your Lordship, may not be required,
That
Your
may
Lordship.
be ignored.
It is also apparent from the press diary that he was labor, Your Lordship.
He is the driver, he was aware about.
Driver means
He was aware,
But
Lordship,
the-
and
but
Lordship, other
But the
co-accused.
offense is not by the driver. Yeah,
He
the
got-
allegation is against the company.
Yes, Lord. But they all are involved.
Heard
Lordship.
Mr. A.M. Khan, learned counsel for the petitioner, also heard Ms. N. Das, learned additional for the prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Jahidul Islam, who has been detained behind the bars since 14/5/2024, within bracket for last 41 days, in connection with Krishna PS case number 38/2024 under section 420/468/379/34 of the Indian Penal Code. The gist of accusation is that on 13/5/2024, one Shri Gopal Chandra Kalita had lodged an FIR. One Shri Gopal Chandra Kalita, Assistant Engineer PWRD Gwalpara West and Dudhnoi TR Division Lakshmipur had lodged an FIR before the officer in charge of Krishnai Police Station, inter alia, alleging that one ANPL construction company had without having had, without having any valid documents and due permission, taken away 80% materials of the Krishna steel bridge situated in Krishna. A departmental inquiry was also conducted in this regard. And during the inquiry, the documents which were produced were not found to be authentic. Stop. On receipt of the said FIR, Krishna PS case number 38/2024 was registered. Mr. A.M. Khan, learned counsel for the petitioner, has submitted that petitioner is only a labor of the said company and he is not aware about the allegations leveled in the FIR. It is also submitted by learned counsel for the petitioner that the petitioner has already been detained behind the bars for last 41 days, and considering the long period of detention of the present petitioner, he may be allowed to go on bail. On the other hand, Ms. N. Das, learned additional public prosecutor, has produced the case diary of Krishna PS case number 38/2024 and has submitted that there are materials against the present petitioners in the case diary, as he was the driver of the crane by help of which the Krishna steel bridge was dismantled. Stop. She has opposed the prayer for bail of the above named petitioners. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of Krishna PS case number 38/2024. Apparently, in the FIR, the allegation is against the company, that is ANPL Construction Company, of which the present petitioner appears to be only an employee. Be that as it may, from the perusal of the case diary, it appears that the investigation has fairly progressed, and also considering the fact that the petitioner has already been detained behind the bars for last 41 days, his further custodial detention may not be necessary if he cooperates in the investigation. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Gwalpara, with following conditions. Condition number 1 and 2. Send back the case diary. This bail application is accordingly disposed of.
All right. Lordship, in this case, last occasion, I took time to go through the record. Your Lordship asked me his involvement, but the CD portion is not available with the record.
CD is not there.
Not there, madam.
What is to be done?
That may be confirmed, madam.
That may be confirmed.
Heard Mr. M.H. Chaudhary. Also heard Mr. R.R. Kaushik, London additional public prosecutor, who submits that on perusing the scanned copy of the records which have been received from the learned trial court, it appears that same does not contain the scanned copy of the case diary of Bajari Chera PS of Ratabari PS case number 236/2023, which would be necessary in this case. Considering the submissions made by learned counsel, let the scanned copy of the case diary of Ratabari PS case number 236/2023 be called for from the Court of Learned, Session Judge Karimganj. The registry to take steps for requisitioning the aforesaid scan copies.
Well, along with up-to-date status.
Along with the up-to-date status of the special NDPS case number 130/2023 from the trial court. Let this case be listed. When?
It takes some time, after vacation, lordship suggested
23rd.
23rd night.
Let this case be listed on 23rd of July.
April.
Date opinion.
Proceed in item number 60, we have received the CD just now, my lord. Can it be fixed after some time?
It is an NDPS matter.
NDPS matter, lordship, we have a contention regarding this lordship.
Quantity.
Quantity.
Okay, let them go through the case. Their contention is that container is not weighed and therefore the quantity may come down to intermediate quantity. You will check that. We'll take it up after some time. Let him go through.
Second half, please.
Second half.
Obliged to.
May it please your lordship. So it's a 439 application, my lord. Under the Assam Cattle Preservation Act, my lord, will find the FIR at page 12. May I read the FIR, my lord?
How many days you have been?
My lord, I have been in custody since 15/6/24, my lord. So it's been 9 days. But we were the laborers who were transporting the cattle, my lord. There were 8 numbers of cattle we were transporting. We were neither the owners of the cattle, my lord, nor we were the recipients, my lord. We were entrusted with transporting the cattle, which we were doing. Now the cattle has already been seized, my lord. We have also been in custody for 9 days, my lord. Further detention may not be necessary, my lord, in this case.
No, but why your prayer was rejected?
Our prayer was rejected at the initial stage because, my lord, we put it up before the, considering the fact that this is at the very initial stage, my lord, so the learned trial court rejected the bail application, my lord. But the reason given is considering the allegation and considering the nature of the alleged offense, my lord. So it was at the very initial stage, my lord, on the very first day, my lord, which we had when we had moved the bail application and it was rejected, my lord. Now, my lord, since the cattle have been recovered, our detention was not going to serve any purpose, my lord.
But the allegation is of theft.
My lord, that part is also, now that part has also become redundant in the sense, my lord, the cattle have already been recovered. The allegation has, nobody has come forward claiming that these are my cattle which have been stolen. There is a suspicion, my lord, the suspicion was raised that these cattle may have been stolen, my lord. In any case, my lord, the stolen property has been recovered. It is in the custody of the police. Whether our custodial detention in any way is going to aid the investigation, my lord.
And it seems that this is a interstate transportation, my lord.
My lord, if they take the plea of interstate, my lord, then there's a problem, my lord. Because West Bengal does not have the Assam Cattle Preservation Act, my lord. So if they take this plea that this has come from West Bengal, my lord, it is not an offense there, my lord. Only offense will be where we are transporting it within the state, my lord, for the purpose of slaughter and etc. The other issues will come up, my lord. I am humbly submitting that length of detention may be considered, my lord, and since they already have the cattle, my lord, we have been in custody for 9 days. They have already rigorously interrogated us, my lord. Our further detention is not going to aid the investigation in any manner.
And that we are also transporting it on foot, my lord. So to even presume that we could have brought it from West Bengal on foot, my lord, that would be a bit preposterous, my lord.
We are fixing a short date for case diary.
Yes, any date within this week, my lord, on Friday.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. Let the case diary be called for. As perusal of the case diary is felt necessary for consideration of the instant bail application. Fixing 28th for case diary.
I'm deeply obliged. I think, my lord, today, 6th occasion.
CD is not there.
Not there, my lord.
You are on interim.
No, my lord, it is the problem. It is under section 12, my lord, maximum punishment is 3 years.
Section 12 of
POCSO Act, my lord.
for reasons mentioned in the judgment, this criminal petition is allowed and the further investigation against the petitioner Kavita Dekar in anti-corruption branch case number 7/2019 corresponding to PRC case number 1551/2021 is hereby stopped and quashed.
Item 54. My lord, seeking my lord permission to mention a matter. I'm so sorry. This is okay.
For reasons mentioned in the order in the judgment, this criminal petition is, according to this court, is devoid of any merit and hence dismissed. The dismissal of this criminal petition would not be a bar for the parties to pursue an amicable settlement between them. It took corrections.
Item 2.
Yes, mentioning.
Please, I'm so sorry. My lord, seeking permission to mention criminal petition number 303 of 2016. This is the part heard matter that my lord had heard on Thursday, and it was specifically put for today. In fact, I'm an arbitration counsel. I stayed back for this purpose. Somehow it is not featuring in the cause list. I believe the motion matters are being taken this whole week.
Yes.
So I'm just praying that in case a date be fixed,
When do you want?
second week of reopening, my lord, that is 23rd is
You
a,
have to inform the other side also.
I spoke to them. The second week as per the convenience of the court.
Okay, but now the matter is not listed before me.
Precisely.
Therefore,
Is there
From-
any possibility for my lord to take it up tomorrow? I'm here tomorrow as well.
no, tomorrow, unless it is listed. If it is listed tomorrow, I will take it up.
It was supposed to be listed today. In my lord,
Otherwise, whenever registry listed, list it. We will indicate to registry to list it out in the second week of.
reopening 23rd is a
Okay.
Tuesday.
Okay.
I'm just taking my lord's.
When do you
indulgence.
want it?
So I have completed my side of arguments. It is for
No, you suggested it immediately.
23rd
23rd.
is a Tuesday, 23rd.
We'll request the registry.
It's a-
I will not pass any formal orders.
Precisely. I'm so obliged.
EG slip the potaisi. 23 तारीख है listing them. Yes.
My lord, the petition was arrested on 16/12/2020. In NCB crime number 18 of 20. Then 20B, 2C, under section, and 29. Is under bar 1286 days. Already his co-equus is released on bail.
16/12.
16/12/2020. Only 2 witnesses examined
Out of? Out of?
out of 9. First witness was examined on 12/4/23. Second witness was examined on 14/6/2020. Co-case is released on bail, my lord, by this honorable court.
How many accused are there in the charge sheet?
Two accused.
The other co-accused was released.
Released on bail.
By which bail order? You have annexed the order?
My lord.
At which page?
Page number 18, my lord.
What was seized? 589 kgs of ganja. Yes. Your submission is on delayed.
On delay.
Long incarceration.
Long incarceration.
Any other submission?
Yes, already co-accused is released on bail.
Yes, yes.
Any other submission? Already in the bail of the co-accused, all the matters discussed.
Yes, Mr. Kyle.
Lordship, let's may come to page 11.
Yes.
Total quantity seized was 589.10 kg from truck number so where in the conscious position of one Dhruva Raj and Suresh Ram.
Who is the co-accused?
It is correct that he was arrested on 16/12/2020. Charge were framed on found sufficient material against the petitioners, and the trial is closed. Lordship, on 30th of May 2024. On 30th of May 2024, case was fixed. On that day, Lordship, I am reading this small order. One prosecution witness, namely Manish Modi, who is the seizing officer of the NDPS case number 20 of 21, was present, but his deposition could not be recorded as one of the co-accused in the instant case, namely Suresh Ram, remained unrepresented, and no steps on behalf of him was taken. So the witness was returned back, and next date is fixed on 12/7/2024. Now, Lordship, this has become a regular feature when this honorable court pass order on long prosecution. In trial court, no steps is taken, witness are being returned back. Lordship.
No, but he is under custody.
Lordship, yes, Lordship, may please to see the order dated 35 because record was not called for. Lordship, may please to call for the records and see the order dated 35, what happened on the trial court. Lordship. One side, the trial is being stalled on this or that reason, and the application is being filed for seeking bail on ground of long incursion or delay in the trial. Whether your Lordship will allow such type of yes, it is correct. He is in jail.
And his co-accused granted bail, my lord.
Lordship, it is observed by the learned trial court that one of the co-accused instant case, namely Suresh Ram, specifically, he is the Suresh Ram, remained unrepresented and no steps on behalf of him was taken on that day. Special prosecutor on behalf of the complainant has filed a petition stating that the witness, namely, is now posted in Kochi.
No, the court could have examined him by appointing some legal aid.
Yes, that is up to the court. And we file application on behalf of the Lordship. Next date is fixed on 12/7/2024.
It was the duty of the court to
12/7.
appoint a amicus curiae.
heard Mr. What is your name? Let us call for the report after 12:07.
Lordship.
Heard Mr.
D. Patel.
D. Pathak, learned counsel for the petitioner. Also heard Mr. S.C. Kayal, learned standing counsel NCB, who submits that though the co-accused has been released on bail, however, on 30/5/2024, when the special NDPS case number, what is the case number?
18 of 2024, 18 of 21.
10 of
Lordship, I'm just saying.
28 of
28 of 2021.
28 of 21 was fixed before the trial court, and one prosecution witnesses appeared before the trial court, he could not be examined as the present petitioner remained unrepresented on that day, and no steps was taken on his behalf. Learned counsel for the learned standing counsel for the NCB has submitted that next date of the NDPS case number 28/21 is fixed before the trial court on
12/7.
on 12/7/2024 for examination of the witnesses. Considering the submission made by learned counsel for the learned standing counsel for the NCB, perusal of the order sheets of perusal of the scanned copy of the case record of NDPS case number 28/21 is deemed necessary. Hence, call for the scanned copy of the case record of NDPS case number 28/21 from the trial court, as well as an up-to-date status report as on 12/7/2021 be also called for from the trial court to reach this court before the next date fixed. Let this case be listed again on 18 July. 18 July.
18 July, I will not be available.
Okay, suggested date. 17.
17.
Let this case be listed on 17 July. Registry to take steps for requisitioning the above mentioned scanned copies as well as status report from the trial.
Much of it.
Much.
Item 26.
Here in this case, my name is not there, Lordship. Her name is there, but her senior is due to medical condition unable to attend the court, Lordship. I will be allowed to argue the case on her. Here, your Lordship, he was arrested on 12/8/2022. Here, three-folded submissions are there, Lordship. First, Lordship, that the long incarceration, and second, Lordship, that the contraventions were not recovered from his possession. It was recovered from other persons. Thereafter, 67 notice was issued to him. In compliance to that notice, he went to the office and thereafter he was apprehended. And third point, your Lordship will see that co-accused from whom the contraventions were recovered, they were granted bail, page 89, your Lordship order.
Just a minute. Page 89.
Page 89. Here in this case, Lordship, this is arising out of our High Court order, Lordship. And here your Lordship will find that the person from whom recovery was made, he was granted bail and nothing was recovered from this petitioner. Therefore, considering that Honorable Apex Court granted bail, Lordship. I am on similar.
No. Page 89 is the bail order of the
Co-accused.
co-accused.
From
And
his possession and from another person, it was recovered.
And the Supreme Court's,
Supreme Court's order, Lordship may kindly see in middle portion, having regard.
no, this is in regard to who, which accused? Maqbul Hussain?
Maqbul Hussain, that is, in that case, from Maqbul Hussain, nothing was recovered.
This is a separate
Separate
case,
case,
your side,
separate
okay, okay.
Separate case. The ratio that I am relying on, having regard to the undisputed fact that the other two co-accused from whom the recovery of the contraband and mobile handset was made, having already been released by the court and the same have remained unchallenged at the instance of the respondent state. Further, considering the additional fact that the present appellant was implicated at the instance of the statement of the co-accused, the accused deserved to be released on bail. Here in my case, Lordship, the co-accused has not named me, in fact. The only ground of arrest is that they found telephonic conversation. And in my statement recorded under 67, your Lordship will find that I have not denied that I have acquaintance with him. He went to my place in Hornbill Festival. At that point of time, I came to know with him. That is not disputed by the accused, except that there is nothing to implicate that, except that relation. It is nowhere said that those conversations were in relation to contraband. That is not there in the record. On merit, that part, and in Lordship, delay part, that is 1 year, 10 months, 13 days in custody. Only 4 PWs out of 8 were examined in this. And page 15, your Lordship will find that from whom the contrabands were recovered. Page 15.
Your submission is that the only implication against you is the telephonic conversation.
Telephonic calls. They have not
Calls.
they have not disclosed what type of conversations were there.
That you call
Yes.
him, that is only
That is only the-
CDR details.
yes, CDR details.
Okay.
And even in fact, there, if your Lordship kindly turn
What
to,
was the conversation?
that is not there. Page 19, if your Lordship kindly turn to page 19. On receiving the notice, I appeared there. My statement was recorded. Page 19, down below, your Lordship will find that I have not denied that part. Because I was not aware about what business he is doing. Lordship. Page 19, down below, your Lordship will find.
Yes. Yes.
Yes, I know Abid Parvez, alias Azad Parvez from 2019, and he, along with his wife and son, meet me at Hornbill Festival at Kohima, but I do not know Vijay Kumar Sahu. He is another accused. So I admitted that part that I know him. Merely I know him. That is not that cannot be ground to a detain me. In my humble submission.
Yes. Anything else?
Let me complete.
Okay, yes, yes, sir.
See, first, he was arrested and charged with friend on being found sufficient matter against all the accused. And trial is going on. Admittedly, 4 witnesses have been examined.
How many accused are there total?
Lordship,
How many are on bail?
One on bail.
1.
The main accused from
The
whom
person from whose possession contraband was.
Lordship may come to page 50.
No, the person from whose possession contraband was recovered is on bail.
Yeah. Maybe, Lordship. I'm placing the materials against.
No, that is his submission.
No, yes, Lordship. This is the submission. I've noted that, Lordship. Lordship may come to page 50, paragraph 62.
Yes.
I'm reading paragraph 62. That during investigation, it came to that Abid Parvez, alias Azad Parvez, was well known to Rajitilo, the present petitioner, and they knew each other from 2019. In the year 2020, before COVID, Rajitilo delivered 4 cases of heroin to Abid Parvez. And this time
No,
also,
what is the basis?
this is the during the investigation, it has come to the light. This is a part of final complaint. And regarding Lordship, it will be they will be able to prove during the trial
It is of 2020 and date of incident, if I am not wrong, 8/4/2022.
Okay.
62
During
relates to
yes, read.
This is earlier incident.
Earlier incident.
Yes, Lordship.
Okay, okay. Yes.
4 kg of heroin to Abid Parvez, and this time also delivered him 1.4 kg heroin. Abid Parvez,
No,
along with
Mr. Kayal,
Lordship.
I want to know that is there any material in the case diary or in
No, Lordship,
on
this
the
is
basis of which
this is a
this statement is made by the investigator?
no, Lordship, this is a final complaint. This is a made by the statement made by the this is placed before the court, and on being found sufficient material, charge has been framed.
No, no, I'm not on that. I just want to understand. The IO, this is the charge sheet. This is the final complaint.
Yes, this is a final complaint.
In the final complaint, complainant is saying that Razo Sibzo delivered 1.045 kg of heroin.
That was discovered during the
No,
investigation.
I just want to know, is this only an accusation or is there any material?
No, Lordship.
Because in complaint you made accusation against the accused.
Yes, Lordship.
So after what is the basis of this? What materials are there on record to
That's Lordship, I have to.
that would be necessary to consider 37 embargo? Mere accusation is not enough.
No, Lordship, here. In
You understood my question.
yes, I have understood. Lordship.
That in complaint you are accusing that so and so is recovered, he delivered 1 kg.
Earlier, in
On
earlier
what basis? Earlier, there may be some proof, but in this case, that he delivered 1.045 kgs. What is the basis on which this accusation is made? If there is no basis, if there is some basis, you point out.
What's the page 53?
Yes.
Name of the petition is 1, 2, 3, 4, 5, 6, 7, paragraph 7. Rochitulo, son of Asik Hope. He is the main supplier of seized 1.45 kg of heroin and is doing this illegal business for a long time. Rochitulo supplied the seized 1.0 heroin to a Parvez and received the seized heroin from Hemokholal Lukim. In his voluntary statement, Rochitulo accepted the same and also identified the photos and discloses the mobile number of
So one basis is the voluntary statement of the accused.
and CDR analysis proved that there was 28 calls in the last 1 month, and seize and frequency and length of calls proved that both them were well in touch with for illegal business of heroin. Then his frequent mobile communications with his 2 mobile numbers and timing and length of conversation with so-and-so proved that he was in continuous touch with Abid Parvez to deliver the seized contraband. He also named some other persons as supplier of heroin, that is Mo Anti of Dimapur and Rohit from Imphal, from whom he used to collect the consignment of heroin. He also stated that in 2020, before COVID, he supplied 4 kgs of heroin.
Yes, please
And Lordship,
continue.
paragraph 4, he also named some other persons as supplier of heroin, that is Mo Anti of Dimapur and Rohit from Imphal, from whom he used to collect the consignment of heroin. He also stated that in 2020, before COVID, he supplied 4 kgs of heroin to Abid Parvez, alias Adej Parvez, and this heroin is received from Rohit. It is indicated that he has supplied heroin to Abid Parvez in earlier also and performing this illegal business for long time. Rochitulo also stated that he used to supply heroin to a persons namely Papu Sonar of Bokazan. There are 21 calls between Rochitulo and Papu Sonar, which proves that both are frequent in contact for this illegal business. And Lordship knows after Tufan Singh, it has become difficult for the department to rely on the statement of even the accused or co-accused. But other materials that will be proved during, if they will be able to prove, then lordship, they will be convicted, otherwise they will be acquitted, lordship. And lordship, no, this is a organized crime, lordship. It is very difficult to apprehend other persons, lordship. And it is correct, lordship, that during trial, the statement of co-accused cannot be accepted as evidence. But lordship, if some other materials are there, then
No, I want to know what other material.
that lordship, this is the materials I read out before you, lordship. At this stage, I can submit only this. Lordship, with regard to judgments by orders passed by the Honorable Supreme Court, one referred by my learned friend. These are the only orders. No case has been considered on merit. So there cannot be termed as a precedent, lordship, or to be cited in other cases. Many cases, lordship, Honorable Supreme Court has passed order under 142 and other provisions of law, and without even without considering the merit of the case. So in my humble submission, that cannot be taken as a precedent in other cases also. And in case of bail, lordship knows in many judgments, Supreme Court held that there cannot be parity. Even if a co-accused is allowed, lordship is to consider its own case, its own merit.
Okay.
Just
is
another
Mamad
citation
Sir.
I have handed over, lordship. This is exactly on my case. Here also the High Court granted bail because there was 67 statement and CDR was there. Against that, they went to Supreme Court. Just I have handed over. Paragraph 8, your lordship will find. Seventh line, that case numbers are there. Thereafter, heavy reliance has been placed by the petitioner NCB on the voluntary statements of the accused and the co-accused recorded under section 67 of the NDPS Act for arresting them. Another piece of evidence referred to the CDR details in respect of A3, A4, referred to in respect of the first case. Then lordship may kindly come to paragraph 9. Having gone through the records along with the tabulated statement of the respondent submitted on behalf of the petitioner NCB and on carefully perusing the impugn orders passed in each case, it emerges that except for the voluntary statement of A1 and A2 in the first case and that the respondents themselves recorded under section 67 on the NDPS Act, it appears prima facie that no substantial material was available with the prosecution at the time of arrest to connect the respondents with the allegations leveled against them of indulging in drug trafficking. It has not been denied by the prosecution that except for the respondent SLP criminal so none of the other respondents were found to be in possession of commercial quantities of psychotropic substances as contemplated under the NDPS Act. It has been held in clear terms in Tufan Singh so that a confessional statement recorded under section 67 of the NDPS Act will remain inadmissible in the trial of an offence under NDPS Act. In the teeth of the aforesaid decision, the arrest made by the petitioner NCB on the basis of the confessional voluntary statement of the respondent or the co-accused under section 67 of the NDPS Act cannot form the basis of overturning the impugn order releasing them on bail. The CDR details of some of the accused or the allegations of tampering the evidence on the part of one of the respondents is an aspect that will be examined at the stage of trial. So ultimately, their case lordship challenging that bail order was rejected by the Honorable Apex Court.
Okay.
Here, lordship, some difference is there because here allegation is that he was a supplier and he has admitted all the slips are there.
(27)(6).
Yes. And lordship, another case, co-accused Vijay Kumar Sahu, item number 59.
Same case.
Same case, same, from arising out of the same company. But here, contaminant was seized from his position also.
No, Lordship. Not this
In this case,
59.
27. Heard Mr. A. Azad, learned counsel for the petitioner. Also heard Mr. S.C. Kayal,
Your position, what I said.
learned additional, learned standing counsel, NCB. Let this case be fixed for delivery of order on 27/6/2024. Into
How-
Logot. 15. Yes, 59.
59 Lordship. But I am for Vijay Kumar Sahu, Lordship. He is behind over for 2 years, 2 months, 14 days.
What is your date of arrest?
The date of arrest is Lordship.
Same.
10/4/2022. Lordship, the co-accused has already been analyzed on bail. That is on page 60, Lordship. Lordship, page 59. Operational portion is on, see, Lordship, page
Okay, no,
68.
co-accused I have already, because same co-accused.
Lordship. Nothing.
What else is your submission?
Personally, also nothing has been recovered from my possession. The LS heroin was recovered from the co-accused who is already on bail. He is Abid Parkes. I am Vijay Kumar Sahu, Lordship. Can you see the order, Lordship, passed by this honorable court? Operating person is on page 6. Para 4.
No, what was found from you? Why you?
Lordship, I am, as per allegation, I am co-passenger. My seat number is another and his seat number is another, Lordship. It is, Lordship, see, page 60, Lordship, para 4. Page 60, para 4. Lordship, passed by this honorable court. Page 60, para 4. The NCB team, along with independent witnesses, boarded the course number 54 of Vivek SFS Express and apprehended 2 accused persons, including the present petitioner, who are sitting at seat number 9 of the said course on search of the baggage carried by the present petitioner, and heroin kept in 2 separate packets with weighing about 1.045 kg was found from the possession of the present petitioner. The present petitioner, he is Abid Parkes.
And where you were sitting?
So my seat number is Lordship. I am sitting. Lordship, page 16 of the final complaint. Para 4. Page 16.
Yes.
Para 4. May I read, Lordship? That at about.
No need to read. It is a
Lordship.
long paragraph.
Lordship.
Just you tell me your seat number.
Lordship, my seat number was post 54, no, 36.
In the same coach.
Same S4, yeah. Course number S4, yeah.
So different compartments were there.
Yeah, Lordship. Compartment is different.
Okay. Yes.
Page 18, paragraph 11.
Yes. Para 11.
Yes, that Abid Parvez, Lordship got.
He is not Abid Parvez.
No, I'm reading, Lordship will get materials from this paragraph.
Oh, during his statement, what
Yes.
is, okay, yes.
Stated in Bhole's statement that he is doing the business of illegal drug for last 22 years, and he was sentenced to jail from 2002 to 2015 at Deccan Jail, Odisha. In the case of seizure of 170 kg of ganja. After releasing from jail, he continued the illegal business of drug and accompanied Vijay Kumar Sahu, present petitioner, in his business, whom he met in jail. Vijay Kumar Sahu joined him for the sake of money. Abid Parvez, alias Azad Parvez, also stated that he used to purchase the drugs from Jai Singh of Zone of Dimapur. And Banram and Santosh are associated of Jai Singh and assisted his business of illegal drugs. Abid Parvez also named another persons, namely Narayan Prasad, who is associate of Jai Singh and reside in Calcutta and Odisha. Abid Parvez also revealed that he, along with Vijay Kumar Sahu, present petitioner, visited Dimapur on 10/2/2022 to collect delivery of drugs, but did not collect it. Abid Parvez disclosed the mobile numbers of all four mentioned persons. Then Lordship, page 34,
30?
page 34,
Yes.
top Lordship.
Yes.
Vijay Kumar Sahu, son of Manguli Sahu. He is associate of Abid Parvez alias Azad Parvez and help him to collect the consignment of heroin and earn rupees 4,000 to rupees 5,000 per trip to assist Abid Parvez. Vijay Kumar Sahu along with Abid Parvez planned to take delivery of heroin from Dimapur and acted as per their planning. They also came to Dimapur in February 2022 to collect the delivery of heroin, but that time they also not received the consignment. His travel history make it very clear that Vijay Kumar Sahu along with Abid Parvez frequently visited Dimapur, Nagaland to receive various consignment of heroin, and Vijay Kumar Sahu is a long time associate of Parvez in illegal business of heroin. Vijay Kumar Sahu met with Abid Parvez at Deccan Khal jail where he was imprisoned for 14 years, and after releasing from jail he joined Abid Parvez in illegal business of heroin. It ensured that Vijay Kumar Sahu is a repeated offender and have a past criminal history. What more required, Lordship?
Lordship, may I please?
No.
Lord,
And they have a past criminal history also. He was jailed for the illegal business of narcotic. Lordship.
may I please?
This is my
There is allegation but not related to this case, Lordship. This is the last order of the trial court. See, Lordship, this is the last order.
This is item number 50.
I have highlighted Lordship. See, Lordship, it is 31/5/2024 order dated. PWs are absent. Summons be issued to the West PWs. And next that is 14/6/2024 is production and.
How many witnesses are there total?
Lordship, 8.
Only 4 are examined.
Lordship, out of 8, till that four examined. But it is the status of the earlier status when the co-accused was enlarged on bail. The co-accused was enlarged on bail 28th of April 2024. And on that day, the status was the same. Today's status is the same. Lordship.
Okay. Heard Mr. A.K. Soharia,
Yes, Lordship.
learned counsel for the petitioner. Also heard Mr. S.C.K.R., learned standing counsel NCB. Let this case be fixed for delivery of orders on 27 June.
Lordship, here section 31 will be to be considered by Lordship.
30?
31 of NDPS Act.
What is that?
That is enhancement of punishment for offences after previous conviction.
You have previous,
Yes, he was previously convicted for 18 years. He was in jail in
No.
Odisha.
that would be applicable
Yes, Lordship, that will be applicable at the time of passing the judgment.
if you are able to prove his conviction in this case. Then
Yes.
the question of previous conviction.
There are so many judgments to that effect. Lordship, want I can place that judgment.
No. That now we are concerned with materials available against him in this case.
Lordship can consider also previous conviction. In case of Pramu also, Supreme Court has considered this aspect of the matter. And anticipatable was rejected by Supreme Court because he was found to be involved in another cases also.
If there are materials, if we find material against the petitioner in
Yes,
this
Lordship.
case,
Because Lordship, let them deny that they was not convicted because burden lies on them. Once I made statement, presumption can be taken by a Lordship.
okay, I will consider the question of previous conviction is to be considered
Yes.
addedly
Yes, Lordship.
in addition to
Is a-
considering the facts of the
present
present case.
Yes, Lordship.
First, we have to examine the materials in the present case.
Present case and the.
If suppose nothing is found in the present case, then previous conviction would not help you. if something is
No, Lordship,
there in the present case.
my submission will be, Lordship, London trial court has framed charge against all the accused persons on being found the prima facie materials against them. Whether at this stage, in case of bail, whether we can negate all these materials,
Yes,
please before the trial court.
that we will consider.
Yes, Lordship.
That while considering bail, what this court can consider or not.
That I'll place the judgment, Lordship, if required. There are
Right.
many, tomorrow itself, Lordship. I'll supply to the court master, Lordship.
But earlier occasion lordship in allowing the co-accused person lordship in the said order, page 68 lordship in para 26, 25, 30, 29 lordship. This honorable court was pleased to elaborately discuss regarding delay in completion of trial regarding article 21. Lordship.
27.
Lordship. Deeply lordship.
Thank you, ma'am.
Item 28.
28.
May it please your lordship. Lordship. In the morning hours, lordship was pleased to put the query as to the date of arrest, my lord.
Yes.
My lord, the
Binding
witnesses
file.
before your lordship, they are admittedly the driver and the handyman, my lord, of the truck in question. Lordship, apart from the long incarceration and lordship, the detailed judgments of the apex court as well as this honorable court, where this honorable court has gone at length to discuss the judgments, Mohammed Muslim and lordship, the ancillary other 8 to 9 judgments, and lordship from the other side as well, lordship, the judgments provided by the NCB, my lord, where my lord, section 37 has prevailed over the article 21, my lord. My lordship had gone at length and lordship has provided judgments in certain matters. So would like to place those judgments. And prior to that, my lord,
What is your, how long you are detained behind the bar?
my lord, I have been behind bars for 2 years, 1 month and 6 days, my lords, as on date. My lord, the contraband in question here is 530 kgs of alleged ganja, my lord. That, my lord, would be apparent at page number 20, my lord.
And
Page number 20.
how many petitioners are there?
My lord, 2 petitioners, my lords.
You
They are the only accused persons. They are the sole accused
They are
person.
the driver and helper.
Driver and handyman, my lord, of the alleged truck, my lord. My lord, apart from the long incarceration, my lord, a humble submission before this honorable court is that, my lord, the seizure with regard to the instant case, my lord, that under section 42 and 43 of the NDPS Act is vitiated in this instant case.
Why?
My lord, may look at page number 20, my lord, point number 3, place and date of seizure. My lord, initially detected for that point, my lord, page number 20.
Yes.
Page number 20, point number 3, place and date of seizure detention, my lord. My lord, this vehicle was apprehended at toll gate, Bakarsal, Karimganj district on 18/5/22 at about 9 p.m., my lord. However, my lord, the seizure was made on 19/5/22 at 600 hours in the morning, my lord. So that is the thing. That is the admittedly, my lord, from the prosecution's document that, my lord, on 18th, the apprehension was made and the seizure, my lord, was made on the subsequent date, that is 19th, my lord. My lord, the same, my lord, and there is no document or there is no submission in the filing complaint with regard to, my lord, as to where and then under whose possession these articles were kept during that period. And, my lord, very interestingly, at page number 32, my lord.
No, your submission is that at 9.
Seizure was not made at the point of, my lord, apprehension, my lord. That, my lord, of course, is a matter of trial, my lord, when the IOs and the prosecuting officers from the prosecuting agency, when they would be examined, my lord. But, my lord, for that occasion to come, my lord, probably would take years, my lord. Considering that from 1 year and 2 months, one prosecution witness has not yet been completely examined.
But my lord, in paragraph 15 and 16 of the final complaint at page number 32, my lord, this has also been clearly stated. That my lord, they are stating that the seizure was made at on 18/5/22. My lord may come to page number 32, paragraph number 15. Where they are stating, my lord, page 32, para 15. Para 15. Here, my lord, it is stated that the seizure of 530 kgs of ganja was made on 18/5/22. Whereas, my lord, their inventory itself speaks differently, my lord, at page number 20. And my lord, paragraph 16 at page number 32 only, my lord, which states that the seized articles, which means including the ganja, alleged ganja, my lord, and the relevant documents were deposited in the NTPS Central Godam Disposal Unit Customs Division by memo number NR 14/2223 on 25/2022, my lord. Apprehension, my lord, at the toll gate was made on 18th, and my lord, contraband goods were deposited on 25, my lord. This vital gap of, my lord, 2 calendar days, my lord, how relevant that would be, my lord. My lord, of course, my lord, understood, my lord, these would be, my lord, points to be taken up, or my lord, while the witnesses are being cross-examined. But to avail their opportunity, my lord, possibly the accused person would require years, my lord. So, my lord, here the point of, my lord, long incarceration and balancing Article 21 with Section 37 of the NDPS comes into the picture, my lord. And apart from this, my lord, one additional submission is that, my lord, from the final complaint itself, if my lord peruses page number 34 and 35, my lord, that is paragraphs 23, 24, and 25, it is seen that, my lord, the entire consignment, which were packed in packages, were loaded by, my lord, one DARCL Logistics on behalf of, my lord, Apex Rubber Limited from Agartala, my lord, Tripura. While the vehicle was parked at the logistics company premises for more than a day, my lord, in sealed covers, my lord, these were loaded.
The
Identical
ganja
sealed
was
covers.
found inside container in sealed covers.
Inside sealed covers, yes, my lord. Inside packets it was found. That is from their document I'm speaking, my lord. Of which certain packets were, my lord, rubbers, and, my lord, 35 packets were ganja, my lord. So in total 560. This is from page number 20 I'm pointing out, my lord. So 560 packets, identical packets were containing rubbers, and from them, my lord, 35 identical packets were containing the alleged ganja.
Page number?
Page number 20, my lord. Page number 20. In the list, my lord, we'll see point number 1, these 35 packets, they are ganja, my lord. And point number 3, 560 packets, these were natural rubber, my lord. The consignee was MRF Limited at Telangana, my lord. However, neither the consignor nor the consignee nor the logistics company, none have been implicated, my lord. Whereas they have admittedly, my lord, stated at page number 34 and 35 of the final complaint that, my lord, they had supervised the loading and they had done the loading, my lord.
Where it is mentioned?
My lord, at page number 34, my lord, paragraph 23, 24, and 25, my lord. Up to paragraph number 27, my lord, of the final complaint. That the loading was done on their behest and on their instructions and on their supervision, my lord.
Okay. Yes. Yes.
Yes, my lord, those 3 paragraphs. Apart from that, my lord, I pray to place.
Where it is mentioned that these ganja were found in sealed.
Paragraph 4, page 25.
What kind of packets were there? Rubber,
My
rubber,
lord, it was as per the prosecution document, my lord, wrapped outwardly with newspaper and brown color cello paper.
the
which was-
ganja
The
Yes.
ganja, my lord.
and the rubber.
Rubber, lordship,
Thereafter,
last 4 lines of page 25.
which was concealed among the packs of natural rubber, my lord.
So what your investigation said?
Lordship,
It was the driver and the handyman who
Yes.
kept.
Lordship now, Lordship knows after Tufan Singh, we cannot catch hold of other persons on basis of statement. Lordship,
But statement are the not the only means.
no, Lordship, we come to page 25, paragraph 4. Two arguments have been made that seizure was made on 18 and seize was effected on 19. Lordship, may please to see paragraph 4.
Yes.
Page 25, I am reading, Lordship. That, sir, the officer of A Unit Custom Division Karimganj, with the assistance of the other officers of Custom Division Karimganj, headed by Deputy Commissioner Custom Division Karimganj, intercepted 14-wheeler Tata truck bearing registration number so and so at about 21:30 hours of 18/5/2022 at tollgate Barkakhal, Karimganj district, while the truck was coming from Agartala. On preliminary visual examination, the truck appeared fully loaded with covered with tarpaulin. On query, both the drivers and Sahil Sharma and the handyman Sri Akshay Kumar of the truck denied carrying any contraband goods. At that time, passers-by were requested by officer to remain present. There as independent witness for completing the seizure formalities, at which two persons, namely so and so, agreed to become independent witness, as it was not feasible to undergo thorough check of the truck on the national highway. The truck being registration number so and so, the driver and handyman were brought to the custom division of Karimganj. The two independent witnesses also came along with the officers at the anti-smuggling unit of custom division. After reaching the office, some hired laborers were called in presence of the driver, the handyman of the subject vehicle, and two independent witnesses. The unloading, counting, weighing of goods was started, which resulted the recovery of 35 packages containing dried cannabis in compressed form in assorted size and wrapped outwardly with newspaper and brown colored cello tape, which was concealed among the packets of natural rubber. Total 560 packets of natural rubber. Thereafter, the recovery of 35 packets of cannabis was weighted on an electronic weighing scale and recorded one by one in weightman sheet, where total weight for this cannabis measured 533.63 kgs and gross 530.132 kg. The recovered cannabis valued at rupees 79 lakhs 52,000 on odd. The truck valued at rupees 42 lakhs. Only 2,800 kgs of natural rubber of so and so containing 560 packets valued at rupees so and so and various documents found therein as mentioned in seizure memo were then seized by custom officers in it so and so by number so and so dated 19/5/2022. Total with so and so. The inventory of the seized goods was made in a Panchanama was drawn covering the entire sequence of the truck seize, where the two panchas also appended their date of signature. And Lordship, may please to see page 20, subclause 3, my learned friend placed before your Lordship. Place and date of seizure and detention. Lordship has seen the goods was seized on 18 at 21:30 PM. Initially detected the 14-wheeler Tata truck bearing registration number so and so at tollgate number so and so.
Page number?
Page 20. The inventory of seized goods.
Yes, yes.
Clause 3.
So
It was on 19 at 6 hours in the morning. And goods were seized on previous night at 21:30. And cause for bringing the truck to the office was also explained, Lordship.
who loaded these? That investigation is not there.
Lordship, it is mentioned here,
Paragraph 24.
but they have
my
not
lord.
been made accused.
Why?
Because Lordship,
Evidence is not there.
evidence is not there. Only on the basis of the statement of the arrested accused, they stated all these things before the investigating officer.
Lordship, apart from the, with lordship's permission, my lord, I'll draw your lordship attention to page
No,
number
this
34, paragraph
consignment
24.
originated at Tripura.
Agartala.
Paragraph
Tripura.
24, second last line, my lord.
This is the hub of narcotic drugs nowadays.
Whether your investigating officer went to Tripura
That Lordship,
in,
because after Tufan Singh Lordship, the situation is entirely changed. Earlier, they used to arrest all the persons whom the accused persons stated their name is in the statement of recorded under 67. But after Tufan Singh Lordship, even if you make them party, we cannot proceed against them in absence of sufficient materials against them. And this is organized crime, Lordship. Direct evidence we cannot found, and the persons who are arrested from whose conscious position courts have been seized.
no, if you have to, I will not make any observations. If you have to prosecute only the person from whom the contraband is
Seized.
found, then why NCP is required?
No, Lordship.
It can be done by any.
No, Lordship, now after Tufan Singh, this has become the problem. Earlier, Lordship, please to the earlier complaints and others. All the persons who are found to be connected with this offense, they were
If
made
you,
party.
if you fail to find out from where it is originated
No,
to,
ordinary, all information is there. Lordship, just for example, Lordship Akimia. Everybody knows that he's the main kingpin in trafficking of drugs. But in absence of evidence, we cannot be caught off court, Lordship.
no, that duty to
He
collect
was acquitted
evidence
in
is
3
yours.
cases. Lordship, recently he is acquitted in 3 cases of NCB laws.
No,
For-
that what I am saying, that duty to collect evidence is
Lordship,
on your shoulder.
Lordship, it is very difficult to get the direct evidences. Only on the basis of a statement they can be framed.
So the NCB is dependent only on statement of co-accused.
Lordship, this is the only now we are making accused persons only from whose conscious position courts have
Okay,
been seized.
okay.
And Lordship is granting bail to all the accused persons from whose position nothing has been found.
Heard Mr. D.K. Buddha, learned counsel for the
Lordship, another fact here in this case, charge was framed on 30th of August 2023.
And out of 11 witnesses, none of the witness has been.
Lordship, that information I don't have with me yet.
My lord, LCR would reflect, my lord, PW1 is still going on, my lord. Repeated occasions for documents and for unavailability of witness, time was short, my lord. LCR is there before your lord.
Heard Mr. D.K. Buddha, learned counsel for the petitioner. Also heard Mr. S.C.K.R., learned additional public prosecutor. Sorry, learned standing counsel, NCB.
Custom, Lordship, this is a custom.
This custom.
Standing counsel, Customs Department. Let this case be listed for delivery of order on 17. On 27/6. On 27.
My lord, I have placed not the entire judgment, my lord, I have placed BA number 36424 for your lordship's kind perusal. I stand deeply obliged.
Give a copy.
My lord, I provided a copy.
Okay. Huh? No, NCB clear karo.
Lordship, probably one matter is left. Was anything?
Obliged.
Good to. Yes. Yes, yes. Late please, your lordship. It witness I will.
Mr.
439
Chaudhary,
application, your lordship.
your matter we will take up after NCB matters. After NCB.
Okay, okay, yes. What was last?
Last one. Chance.
Yeah, Lordship, this is a 39 application, your lordship. What has happened here? The petitioner was arrested on 36/20/21. So almost a few 4 days, less than 3 years, your lordship. And there are the charge was framed 2.5 years later on 21/2/2024. Out of the
21 to
21 to 24 charge has been, charge sheet was 24/12/2021. Petitioner arrested on 36/2020. There are 11 number of witnesses. Not a single witnesses have been taken. They have filed an objection, your lordship. In the objection, not a single whisper has been made. Why there was such a long delay in this matter, your lordship, with regard to after about 3 years of arrest, nothing has been done. Both the petitioners, 2 petitioners are there, 3 petitioners are there, they're in jail, your lordship. Since 36/2021, petitioner 1 and 2, third petitioner was arrested on 28/7/2021. That is also almost 3 years. And the first 2 petitioners, nearly 3 years. And the objection has also been filed where they have not a single whisper has been made. Why? There is this delay. And secondly, why there was so much of delay in your lordship framing of the charge. And after framing of the charge, there were another 2-3 occasions when PWs have not, your lordship, appeared, and not a single witnesses for the last 3 years. Basically, my case is on long incarceration. I'm not going into the merit of this matter.
That's it.
yes, Mr.
Randir
Khan.
Kumar.
Lordship, in this case, charge was framed on 21/2/2024.
Yes.
Yes, that
And delay, as stated by my landed friend, that will order severity reflect because process were issued against co-accused. They were found to be absconded.
okay.
So Lordship, it cannot be said that there is a delay in trial due to the fault of the prosecution. Also. And Lordship, further, I want to place page 79.
Page
79.
The name of the accused is Pappu.
Pappu
One
Yadav,
is Pappu, yeah.
one is Randir Kumar,
One is Randir, one is Pappu.
Pappu, and another is Rahul Kumar.
Rahul, all the 3.
Page 79, paragraph 64. That the seize 715 kgs of ganja, which is a commercial quantity seized from the tanker bearing registration number so and so, and which was in conscious possession of Randir Kumar and Pappu. That the voluntary statement given by Randir Kumar that Sanjay Roy and Ranjit Roy and Rahul Kumar that is offered him to bring the ganja from Tripura
No, your submission is that there are materials against
him.
There is no denial. He is not
I'm not going into the merit.
on merit.
No, Lordship.
Materials, assuming that there are materials.
Even then, Lordship, because charge was framed in February 2024. Lordship, question of long incantation will not come in this case. Lordship.
Your reply is that prosecution is not at fault.
Yes, Lordship. This is the process of the court, Lordship. Lordship, in earlier case, Lordship, my landed friends, case of the council have submitted that goods were loaded, but they were not loaded. And this is case suffered from that, Lordship, because 3 accused. Conscious possession recovered of the contaminant was from position of 2%. And on their involvement, they were made party.
Okay.
So this aspect of the matter is not to be considered by Lordship.
Heard, Mr.
And one
White.
more thing, your lordship, just replying to his submission. Your lordship, all the 3 petitioners were in jail. There was no question that they will delay the matter. If any delay is there, this is not the fault of the petitioners. That's all.
Is that the system is there, Lordship?
No, you cannot, if there is a system, blaming on the system, you will continue like this, your lordship.
System has to be improved.
No, that is,
Somewhere it has to be
that-
corrected, your lordship.
that's why we have operate for lordship to pass necessary order. Directing trial court to frame some policies.
Heard Mr. Y S Mandan, London Council for the petitioner. Also heard Mr. S C K, London Additional Public Prosecutor. Let this case be listed for delivery of order on 27 June.
Get a witness, sir. Get a witness, right? Witness, get a-
Are with us. One more is there.
One,
Yes,
item 58. 58, no? Here, your lordship, in this case, the petitioner was arrested on 4/6/2018. And charge sheet was filed on 11/12/2018. There were 11 witnesses. Out of them, your lordship, only 4 witnesses have been examined. And all the 4 witnesses are the officers of the NCB.
No, DRI.
Sorry, DRI, sorry.
Out of
Yeah.
11, 4 were examined.
4 are examined and all the are officers of the DRN, your lordship. One thing I would like to point out, apart from the long incarceration of 6 years in custody, your lordship. In this case, all the 4 other witnesses that has been examined, your lordship, those I have annexed all the witnesses. That is from page 60, sorry. Starts from page 37 only. From 37 onwards, the first PW1 is the, your lordship, the officer, senior intelligence officer of Director of Intelligence. I'm just naming that. PW2 is, your lordship, is the intelligence officer, your lordship, of DR, and your PW3 is the senior intelligence officer of DR, and PW4 is also senior intelligence officer posted at DRI Guwahati. All these officers, your lordship, and I will just, if your lordship wants, I can point out the material irregularity in the statements made by all these 4, your lordship, officers. They themselves had made this irregularity. I'll just point out 1 or 2. I'm not going to read everything because that is, if there is also a case by the Honorable Supreme Court where there was a instance where it says that if the possibility of conviction is seen to be very remote, then bail has to be there. I'll give the judgment also. And just point out 2 things, your lordship. Kindly take up page 54 for a moment.
Yes.
Here, your lordship will see this. This is PW2. PW2 was the search and seizure officer. Sujata Srimati Sujata Dam. Here I will read page 55, the 3rd line. Just this part. Accordingly, we the above named officer moved to the Khanapara Guwahati at around 11 AM, and on reaching near the Khanapara flyover, we kept vigil on the trucks that were coming from Jorabad sides, and at around 5 PM, we spotted the truck bearing number so-and-so and immediately signaled the driver to stop the vehicle. The driver of the said vehicle stopped and parked the vehicle near roadside. Then we approached 2 persons and asked them to become independent witnesses of search operation, which we will conduct in the truck. Those persons agreed to be witnesses of search. While we approached near the truck, we found that 2 persons were available in the truck. The person available in the driver's seat identified as Kuldeep Singh, and the person sitting beside the driver given his identity as Sandeep Kumar and hailed from Moinpuri, Uttar Pradesh. Now, your lordship will kindly take up at the cross-examination, page 57. She has stated very differently in both in cross-examination and examination. Here in cross-examination, page 57, 2nd paragraph, I'll read. I personally did not approach to become, actually, I think it is not very, I did not approach to become 2 independent witnesses in seizure, but we were in a team of officers were available at Khanapara, and one amongst us approached those 2 persons to become independent witness of seizure. But right now, I cannot recollect the name of the particular officer who approached those persons. Now, your lordship, we do not have particular instructions for having two local witnesses for making search in a particular truck on the date of apprehension of the accused of the instant case. Nearer the place where we intercepted the truck, there was a sweet shop. But right now, I do not remember the name of the sweet shop, and the owner and the staff of the said sweet shop were not asked to become witness of seizure. The address of independent witness Sanjeev Kolita is village Rudranagar, PS Sanmari, and address of Hitesh Das is also Sanmari, Red Cross, Rudranagar. I'll take your lordship next page. At that relevant point of time, the Office of Directorate of Revenue Intelligence was situated at Krishnanagar, Sanmari, Guwahati. I'll not read further, your lordship. Now, these two witnesses, independent witnesses, this truck was, your lordship, obstructed at Khanapara. They have got two independent witnesses at Khanapara, whose addresses are in Sanmari, and the office of DRI at that point of time was in Sanmari. So I'm not relating anything, but I'm just showing. And secondly, your lordship, she said that she did not approach the two persons for a witness. And in the evidence, in her examination, she said that she approached the witnesses. Now, your lordship, will kindly turn to page 61. This is another senior intelligence officer. Here, in cross-examination, page 64. Your lordship will see 64, first line I'll read. I'll not read everything. There was no shop around the place of intercepting the truck. Now he is contradicting his own officer. Then in page 65.
So your submission is basically testimony of witnesses.
Yes.
Are contradictory.
They are very contradictory. That is one part. The first part is your 6 years.
6 years.
6 years, 4 witnesses, not a single independent witness.
Yes.
4 officers, other 7 witnesses not yet examined, and 6 years in custody. Basically, this is.
Yes, Mr. Kale, same submission.
436 capital letters.
Heard Mr. Y.S. Anand, learned counsel for the commissioner. Also heard Mr. S.C.K.R. learned additional public prosecutor. Let this matter be listed for delivery of orders on 27.
And long incarceration judgments, your lordship, I did not file. There, I have already quoted
You're
in a paragraph.
Relying on the.
That I have already quoted in my petition in a paragraph. Much. Okay.
Yes.
NDPS, my lord, AB, but my only prayer is, my lord, earlier I came, but charge was filed, so that matter was not.
NDPS anticipatory bail.
Yes, but on the basis of co-accused statement. And someone was issued to me, my lord. I just take to also page 18, my lord. Page 17 is the FIR. Page 16, FIR starts, my lord. Just only one.
Charge sheet has already
Yes,
been.
charge sheet late, man. In the charge sheet, your loss will find, charge sheet is page 21. Page 21. Basically, matter 2 persons, actually, initially 1 person was.
In this case, summons were issued against.
Someone. I shall appear, my lord.
You appear before
I
the.
appear only, my lord, I get some protection, my lord. That's much, my lord.
But no, you are appearing before special judges court.
Yes.
Which has all the powers to give you any relief which you want.
Now, that's there, my lord, but.
Special judge is a very powerful court.
But you're not above your losses, man.
We have same powers.
No, my lord, I don't think, my. Here, so far, this 438 is. Yes.
Special judge
it is there, my lord,
exercising
no doubt.
powers under 437.
No doubt it is there, madam. I think that nobody will be prejudiced, my lord. Suppose because someone has issued, only for me, trial will be held up, my lord. I'll cooperate, I'll appear, madam, from that residence, my. 2 weeks time, madam, I'll appear only, you was given 2 weeks for protection. I shall appear, I shall cooperate, madam. And then let they decide in accordance with law, my. That much prayer. I'm not saying absolute bail, my lord.
No, what do you want?
I want for 2 weeks, my lord. I shall appear within 2 weeks before the special judge. For this period of 2 weeks, my lord, I may give some protection. And then your lordship.
But now only summons have been issued.
Someone, I have been issued, someone might also, naturally, once I appear, I will be taken.
For this 2 weeks, you.
Only, my lord,
When is the
I am not
next date?
saying the absolute bail.
When is the next date fix?
Yes, my lord.
Next date.
For next date is 18/6 it was, but 18th I do not know, my lord. On 14/3/74, it was fixed on 18/6. No, sorry. On 14/6, this last case was there, my lord. Then it was fixed
No,
on, 28/6.
I'm not understanding.
28/6.
The court has issued summons to you. Court, the special, which court?
A special judge, my lord.
Ojai.
Yeah,
Ojai special judge has issued summons to you.
Yes. Page your lawful part.
Nobody will arrest you before that date.
Page 35. My lord.
Nobody will arrest you before
NDPS,
that
my
date.
lord.
No, if there is a summons of the court,
That can, my lord, because.
why are you apprehending?
It is non-bailable, NDPS, my lord, C is there, my lord.
But
So my apprehension is genuine, reasonable one. And actually absconder was there, madam, the charge. Police has declared me absconder.
But the court which is seized of the matter, the trial court,
Court has not yet declared absconder, madam.
trial court has decided to issue summons.
Summons, madam.
So there is no apprehension.
But apprehension might summon your lordship either way, madam. It is true, madam, initial, first of all, madam, warrant of arrest was issued, madam. Someone was issued.
No,
No, I am on the other way, madam. Once I appear in a summons first, naturally court will take me there, madam. My one, I will appear, madam, only 15 days time, madam. Only 15 days time, I am saying.
No, 15 days you have no apprehension. For these 15 days for which you are seeking protection,
Madam.
for these 15, your apprehension will start only after your appearance.
Madam, once I appear, my appearance will be materialized, madam.
No, but for these
That will be
15 days.
executed, madam. Appearance will be executed that time.
Mhm.
But court also may consider in accordance with law, my
Yes.
sense, co-accused statement. I'm not making unreasonable prayer, man. I'm making reasonable. I'm not saying that your lordship was absolute bail order. I'm not saying so. Interest of both the sides should be might have taken into consideration.
Now what do you want?
Unless the matter will remain delayed, my lord, that is why. If that is there, we can say you appear, then the law will take its own course.
So I will say that you appear as per the date mentioned in the summons.
Now, there's someone here, my lord, we got the information. Last date was 14/6/24. In that date, next date was given on 28/6/24.
So on 28.
That is not on record, but it is from the website he got it.
On 28/6/24, you appear before the trial
I
court.
cannot, my lord, because he is somewhere else, my lord. He will have to come.
So on 28, you will not appear.
Not appear, my lord. I cannot do it. I am somewhere else.
Then you go to the trial court and make a prayer that for
120, I cannot, your lordship pass any order, ma'am. I think your lordships are not above, my your lordship. At least what though they concurrent jurisdiction, but your lordship.
no, but I have not understood your apprehension.
In the appearance on my, once I go there, appearance will be materialized, my. But in the meantime, what I mean to say, my lord, because this man, he will not appear even, otherwise he will not appear, man. At least 2 weeks time, if it is given, my lord, at least we can say, you go and appear and you cooperate with the trial, my lord. Only because of him, trial held up, my lord.
And fail to. You don't have any apprehension now.
I have been declared absconder, my lord, by the police, which they cannot also. And court has not said anything on that part.
You either you appear before the court on 28/6 as per the summons and make your prayer before the said court.
In that case, you'll also make some observation, my lord, my submission at least, my lord. On the basis of co-accused statement, my lord. On that
Heard
part also.
Mr. H.R.A. Chaudhary. Also heard Miss H.R.A. Chaudhary, learned senior counsel, assisted by Mr. I.U. Chaudhary. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Ainul Haq, who is apprehending Ainul Haq seeking anticipatory bail in connection with special NDPS case number 38 within bracket H/2024 arising out of Hojai PS case number 530/2023 under section 22C/29 of the NDPS Act, 1985. On the basis of an FIR
Page 16.
lodged by
Lost by one
Ranjit Buragohai
Yes.
before the officer in charge of Hojai Police Station, inter alia, alleging that huge quantity of Sempex Plus tablet and containing tramadol were recovered. How many accused are there?
Yes, it is there, 200, 22 kg, 860 grams.
From the possession of the accused persons named in the FIR, including the present petitioners.
No, present petition, it was seized from my one courier service shop, mine. Not
From the
Huh?
from the possession of
Yeah.
the accused persons named in the FIR.
No, I
And
don't know this.
Stop. Hojai PS case number 530/23 was registered. And investigation was initiated. Ultimately, on completion of the investigation, charge sheet was laid against 4 numbers of accused persons,
Including petitioner showing as responder.
including the present petitioner and the FIR named accused persons. The under section 22 within bracket C/29 of the NDPS Act 1985. The name of the present petitioner has been shown as an absconder in the charge sheet. Learned senior counsel for the petitioner has submitted that though the name of the present petitioner has been shown as an absconder in the charge sheet, the learned session judge Hojai had issued summons to the present petitioner, fixing 18/6/2024 as the date of his appearance.
Initially, 11/4 it was issued, 11/3.
Fixing 11/3.
No. Initially, on 11/3/24, summon was issued. Subsequently, date was fixed. Now, next date is 28. Page 35. The latest order I do not have mine, but that is got from the website. Page 35.
Fixing 12/3/24 for appearance of the present petitioner.
Now matter is fixed on my lord.
Thereafter, the case was again fixed on
19-3.
on
You should mark it as 14-6-24 ultimately.
no,
On
no,
that date is a fixed-
ultimately the case was fixed on 14/6/2024.
On that date, my lord,
Stop.
again,
Learned counsel for the petitioner has submitted that on 14/6/2024, the learned trial court has again fixed the NDPS case number 38H of 2024 on 28/6/2024.
for production, etc. On the website it is.
It is submitted by learned counsel senior counsel for the petitioner that there are no materials against the present petitioner on record except the statement of the co-accused, on the basis of which he has been apprehended. He has been implicated in this case. It is also submitted that nothing was recovered from his possession. And as commercial quantity of contraband is involved in this case, he apprehends that he may be remanded to custody if he appears before the trial court in pursuant to the summons issued to him. In the intermediate period from up to 2028, up to 28/6/2024, only summons are there.
Yes.
Learned senior counsel for the petitioner has also submitted that though
More than I thought.
only summons were issued against the present petitioner, however, as he has been shown as an absconder in the charge sheet, he may be he apprehends that he may be arrested in the meanwhile. On the other hand, and hence he has prayed for grant of anticipatory bail to the present petitioner. On the other hand, learned additional public prosecutor has submitted that as the trial court has only issued summons to the petitioner, there is no apprehension of his getting arrested, and he may be directed to appear before the trial court on the date fixed by the trial court for appearance of the present petitioner. Yes, I have considered the submissions made by learned counsel for both sides. Though it is now settled that anticipatory bail is maintainable even in the case of NDPS, even in the case of offences under NDPS Act. However, before invoking the provisions of Section 438 of the Code of Criminal Procedure in favor of the petitioner, this court has to come to a conclusion that there exists an apprehension of getting arrested by the present petitioner, which on perusal of the records does not appears to be the case. As the Court of Learned Session Judge Hojai within bracket say / Special Judge Hojai has only issued summons to the present petitioner. As the Court of Learned Special Judge Hojai / Session Judge Hojai, before which the trial of NDPS case number 38/38H slash 2024 is pending, is presently pending, has issued only summons to the petitioner. This court is of considered opinion that till the next date fixed in this, mentioned in the summons, there is no apprehension of getting arrested by the, there is no apprehension of the petitioner getting arrested during this period.
On appearance will start, man. So at least that's very good.
The plea raised by learned senior counsel by the petitioner that the only material against the present petitioner on record is the statement of co-accused under section 67, which is not admissible in evidence
Tufan Singh.
in view of the judgment of Tufan Singh versus State of Tamil Nadu reported in so and so. Can
21
very,
OSCC.
can very well be raised before learned trial court on his appearance before the said court. As the said court is a competent court to consider the said plea and consider the bail application, if any, filed by the petitioner on his appearance before the said court. In view of above, this court is of considered opinion that this anticipatory bail application is devoid of any merit and accordingly disposed of. Accordingly disposed of. The petitioner may approach before the learned trial court on the date so fixed and mentioned in the summons received by him. And on his appearance, he may pray for bail before the said court, which shall be considered by the said court in accordance with law. With above observation, this bail application is disposed of.
Yeah, please, your lordship. Lordship, I have appeared before the concerned investigating authority, lordship, but yet I am not being informed what are the set of allegations against me. So on the last date, the police report was called for.
CD is there.
In the motion matter, my lord.
No, he is on interim.
Lordship, I have appeared before the concerned IO, lordship.
You have appeared.
I have appeared, lordship.
The CD is not here because it is listed on motion, so CD was not called for perhaps.
Actually, the thing is, till now, we are not sure what is the exact allegation against me. Why I was called by the concerned police officer, lordship.
Oh, no. Whether any case is pending against you or not, that information was sought for.
Yes, that information was sought for, lordship.
My lord may fix it tomorrow. We'll take the instruction. Maybe. Tomorrow or day after tomorrow. Maybe.
Heard Mr. P.P. Medhi, learned counsel for the petitioner, also heard Mr. R. Kaushik, learned additional public prosecutor. It appears from record that the petitioner from whom you received the notice under
Lordship, ACP Omen Unit, Pan Bazaar, lordship, at Annexure A, page 11.
that this anticipatory bail application was filed by the petitioner after receiving a notice from
ACP Women.
ACP Women Unit Pan
Pan
Bazar on receipt of a complaint by his wife Mosimi Das before the said police commissionerate. It is submitted. Now, do you want to pursue this?
Lordship, I leave it up to you, Lordship. Lordship, Lordship can otherwise dispose this matter also by, Lordship. The thing is this, that, my wife has seen the habit of filing complaint, and till now I don't know what is the exact nature of that complaint. That's why when I appeared before the concerned police officer, I asked, but I was not
Informed. Okay. What was the last name? So it appears that there is no information available as regards the pendency of any case before the Pan Bazar Women Police Station against the present petitioner. Hence, let a report be called for from the officer in charge of all women police station, Pan Bazar, as to whether any case is pending before the present petitioner or not. Learned additional public prosecutor is requested to furnish the said information when telephonic by before on the next date fixed. Let this case be listed again on 26/6/2024.
26 June. And deeply obliged, Lordship.
Well, I tried to find out whether the case is registered or not. Now, the OC said that he is not able to find out the FIR itself. I mean, he has tried his best since 2-3 days, but then he couldn't find out.
So there is nothing.
Nothing registered as such.
But in page 5, in para number 6, your lordship, I have stated some dates, your lordship.
Yes, yes. In fact, what he had said that an FIR was showed also to him, one of the
You
accused
get
person.
a written report.
I'll get a written report then.
In the meantime, your lordship, some protection may be given, your lordship. Because of that, your lordship, as I have been instructed, your lordship, the police frequently visiting the house of the petitioner.
That I think Supreme Court has said it can be done even without the copy of the FIR.
What kind of protection?
Interim protection if he is.
No, whether they will appear or in connection with which case they will get protection. Protection cannot be blanket.
That will be a difficulty, but I remember seeing one judgment where it is allowed. One can move a bail application, but what is done,
How the orders will
how
be
the
passed.
orders.
You suggest.
What the OC told me is that let the person go to him, and then if there is no, without any fear, and then he will apprise them.
Okay, you appear before the.
I will appear, but the fact is that your lordship, since 14/5/2024, 18/5, thereafter 28. These are the dates, your lordship.
Who is the informant?
On Rabiul.
On Rabiul Haq. I've also told him that he is the informant.
Yes.
Okay.
Case relates to some trafficking. 4 years back, the incident took place, and 4 years later, the girl filed and the girl alleged. This is what they have stated.
Okay, heard Mr. A.M. Khan, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor, who submits that after speaking to the officer in charge of Fakiraganj Police Station over telephone, as directed by this court, it has been informed to her by the by the said officer in charge that he is unable to
Trace out.
locate any FIR in the said police station which has been filed by Robiul Haq and needs some more time to locate the same. The prayer is allowed. The additional public prosecutor is requested to get a written report in this regard from the officer in charge of Fakirganj Police Station on or before the next date fixed. That is on 24/7, 2024. In the meanwhile, the petitioners are petitioner number 1, 2, 3, 4, 5, 6, 7, 8 are directed to appear before the investigating officer of directed to appear before the officer in charge of Fakirganj Police Station on or before within 10 days of date of this order, and if they are arrested in connection with any FIR which is filed by Robiul Haq, in the meanwhile, they shall be allowed to go on bail. They shall be, no, they shall be allowed to go on interim bail in the said case, subject to condition that they will cooperate in the investigation. The interim bail shall be subject to the satisfaction of the arresting authority. Let this case be listed again on
24/7
for the report of the officer in charge of Fakirganj Police Station.
Item 16.
16, of course, the FIR is registered. It is registered as 136 of 24 under section 376.
376. 36.
May I appreciate.
Yes.
Lordship, 438 application, your lordship. Case has been registered under 4 of the POXO Act, your lordship.
24, my lord. Section 11, 12 of the.
Some more time for producing the case diary. Prayer is allowed. Let this case be listed again on
My lord, 17/7.
17/70.
Maybe 28, my lord. I have not.
28, it will not reach.
Immediately after vacation on 16/7.
16/7 or 15/7 on
Then
the
better protection may be. I am not.
Arms Act is there, my lord. Let the case there may come. my lord.
Long vacation, my lord. On that incident day, I am not present in this house, my lord.
on 28/6. Right,
Yes, I will try.
right. Let us see whether it comes or not.
Item 49.
That's why I'm on internet. Case there was called.
Is there?
No, my lord. Item number 39 case diary not received, my lord. Petitioner has been.
Heard Mr. D Das learned counsel for the petitioner, also heard Mr. P. Botakur, who prays for some more time for producing the case diary. Prayer is allowed. Let this matter be listed
On my lord, 18/7,
on 18/7. The interim order shall continue till next day.
Can it be on 22nd also? On
Yes.
18/7, I have some.
22nd, 7.
Yes.
Interim order will continue.
Your Honor, senior counsel is suffering from viral fever, so adjournment.
What is your prayer?
Sir, senior counsel is suffering from viral fever, so. we could not be able-
You are praying for adjournment.
Yes.
CD is there.
CD is there.
What is to be done?
May allow for the next.
What is your name?
Nabani. And Kalita.
Heard Miss N. Kalita, who submits that her senior, who is the conducting counsel in this case, is indisposed, and on that ground prays for an adjournment. The prayer is allowed. Let this case be listed again on
28/6, 20. Location of CD.
on 28.
Yes, ma'am.
On 28/6, the case diary shall be retained till next day.
Please, Your Lordship. It's quoted in bail petition, Lordship. Offense, Lordship, under 120B, 370 and 354 of the IPC, Lordship. And Lordship, CD was called for fire, CD is received, Lordship. And Lordship, FIR, Lordship will find type copy at page 11, Lordship. Page 11, Lordship.
Is there?
Yes, sir. Yes, there is.
May I read the FIR, Lordship?
Yes.
Page 11. FIR is lodged by one Lordship Amrin Sultana, Lordship.
What is the allegation?
Allegation, Lordship, that she is the one volunteer of Lordship BJP Delhi Pradesh, Northeast Cell. And I introduced myself to be a Lordship.
Inappropriate touch.
Lordship, that is there.
No, my lord. It is also there, my lord. There are lots of other allegations is also there, my lord.
354 Lordship, inappropriate touch.
And there are other allegations also.
Other allegations also there.
So, Lordship, may I read the FIR, Lordship? Allegation.
When the FIR was lost?
It was lodged on Lordship 14/5. 14/5/2024. And before approaching this honorable court, I approached Lordship the Honorable Court of Session Judge. There, Lordship, I got interim protection. Subsequently, on perusal CD.
After interim protection, whether you appeared before
Yes,
No,
the.
my lord,
I-
in this case,
I
my lord, interim not granted by this honorable High Court.
No, before the session.
No,
You
before the
appeared
session.
before
I
the,
appeared 4 times, Lord. I appeared 4 times.
whether his statement has been.
Yes, my lord, what happened in the session court, initially, my lord, learned session court has granted interim protection.
After perusal of the
Perusal
case
case
diary,
diary
the
is
interim was rejected.
rejected, my lord. His
But-
step for, which, my lord, his statement is available in the case.
But during the interim period, I appeared 4 times, Lordship.
Then whether his custodial detention is necessary.
Yes, otherwise, my lord, material available against the accused person, because, my lord, she has made lots of allegations against the accused person. One of
Let
the,
it be investigated.
yes, my lord. One of the accused person, Sandon Lokor, who was arrested, my lord.
He is
his
released on
statement-
bail on after 20 days.
His statement is also available in the case. Otherwise, my lord, materials is there against the accused person.
Heard Mr. N. Hassan, learned counsel for the petitioner. Also heard Mr. P. Botakur, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Parag Chaudhary, alias Parag Jyoti Chaudhary, who is apprehending his arrest in connection with Hathigao PS case number 94/2024. The gist of accusation in this case is that on 14/5/2024, the victim girl in this case had lodged an FIR before the officer in charge of Hatigaon Police Station, inter alia, alleging that in the month of November 2021, she got acquainted with the present petitioner, who identified himself as a leader of RSS, VHP, Bajrang Dal, etc., and close to the officials. It is alleged in the FIR that since the date of her acquaintance with the present petitioner till November 2023, the petitioner took an amount of rupees 18,31,000 from the informant on various pretexts. It is also alleged in the FIR that the petitioner had offered inappropriate proposals to the victim girl and had touched her inappropriately in his office. However, thereafter, the victim girl again went to his office to get the money back from the present petitioner, who gave the informant a check of rupees 3 lakhs. Stop. The said check was dishonored by the bank on presentation due to insufficient funds. It is alleged in the FIR that the petitioner had mentally, financially, and physically harassed the victim girl. Learned counsel for the petitioner has submitted that before approaching this court, the petitioner had moved an anticipatory bail application before the Court of Learned Additional Session Judge number 4, Kamrup Metro, wherein he got an order for interim bail. And after getting the interim protection, the petitioner appeared before the investigating officer. However, later on, the interim anticipatory bail was vacated by the said court. Learned counsel for the petitioner has submitted that the allegation made against him in the FIR by the victim girl are not true, and he has already appeared before the IO, investigating officer, on how many occasions?
On 4 occasions.
On 4 occasions, and have cooperated in the investigation. However, he apprehends that he may be arrested in this case. Hence, he has prayed for grant of anticipatory bail to him. On the other hand, Learned Additional Public Prosecutor has produced the case diary of Hatigaon PS case number 94/2024 and has submitted that the investigating officer has already recorded the statement of the victim.
on 35/20,
Statement of the victim.
on statement of the, my lord, victim, I'm sorry, recording. That is the statement of the accused on 35/24.
Statement of the petitioner. As
On-
well as other witnesses, including victim statement is recorded.
Yes, my victim statement also.
Other witnesses, including the victim girl. So considering the fact that the petitioner has cooperated in the investigation and also considering the fact that the statement of petitioner has already been recorded under section 161 of the Code of Criminal Procedure. Stop. The statement of victim girl and other witnesses have also been recorded by the investigating officer. Hence, in the considered opinion of this court, if the petitioner continues to cooperate in the investigation, his custodial detention may not be necessary for completion of the investigation of Hathigaon PS case number 94/2024. Stop. In view of above, in the event of arrest of the above named petitioner in connection with Hathigaon PS case number 94/2024, he shall be allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Send back the case diary. This case is accordingly disposed of.
Deeply obliged.
May please, Your Lordship. I am item number 1 of production list, Your Lordship. I am on behalf of accused Sajidul Islam, Your Lordship. Item number 1 of production list, Lordship.
Item number क्या हो सकता है ये हमें से? Just okay.
Lordship, in this case, Your Lordship, the accused was initially arrested on 5/5/2024, Your Lordship, and he was forwarded on 6th May, Your Lordship. Sajidul Islam.
Where is the FIR?
Lordship, at page FIR is impugn FIR at page 21, Your Lordship. Annex 4, page 21.
It will be.
Lordship, Mary,
No, what is the accusation against you?
Lordship, on the basis of statement of the accused that arrested in connection with this case, one Tomser Ali, and he has been released on bail, Your Lordship, and nothing, no whisper in the forwarding report against me, Your Lordship, and I was merely, it was arrested on shown arrest, Your Lordship. Initially, I was arrested in Hathigaon PS case number 86, Your Lordship.
When? When?
On 5/5, Lordship. And in this case, I was released on
5/5, you were arrested or shown arrest?
on 5/5, I was arrested.
In Hathigaon PS case number 86.
86.
And when you were shown arrest?
And I was shown arrest in on 10. On 10/6.
No, एक केस तो Hathigaon 86 में 87.
87.
It to 87. Number 87 और केस है भी नहीं ना. It to
And it is
production.
production basically in motion.
287 case diary is
No,
not
my
there.
lord, 87 case
Then
diary.
why it is tagged with this?
My lord, in the morning hour, he, my lord, paid before this honorable court did the same case there. I pointed out. My
It
lord,
is not
Out of-
same case diary.
Out of same FIR.
my lord, there are three
Same
different.
FIR.
No, my lord, same FIR. There are three different cases against the accused persons. My lord, Hatigao PS case number 86, Hatigao PS case number 87, and my lord, one another case, Bosisto PS case.
87.
That is, my lord,
It is-
listed as item number 6. So, my lord, right now only Hatigao PS case number 8624 is available with me.
That is item number 33.
287 is not.
No, my lord, 87 is not available. my lord.
Yes, Mr.
Only 87, my lord.
Which is the connected case?
Lordship. Item number 6 connected you.
Heard Mr. S. Hussain, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor. Perusal of the case diary would be necessary. Hence, let the case diary be called for. When will you call for the case diary?
Immediately on 16/7.
Short date may be given you.
No, you have mentioned wrongly in the morning. And then you have listed.
Lordship.
I am for the item number 6 and 33.
I am not taking up 6 now. I am taking up production. This is not connected with the
Lordship,
case.
connected, Lordship.
It is not connected.
Item number 6 and this one is same out of same
How
FIR.
it can be connected, my lord, different.
There-
my lord,
there
how
are-
it
Same
can-
FIR.
No, same FIR.
Oh.
এটা 86, আপনার এটা
Item
87
number 6. There.
287. 6 is 287. Bokisto PS case number.
Bosisto PS case number 38024.
6 item.
Item number
287.
287, my lord, that is
Yes.
not connected, different case.
No. Item number 6 and production list.
CD9 now,
One.
case diary 9.
Is there in hand, out of same. Custodial
In
detention.
6 case diary is not there.
No, my lord, 6 also, my lord, case diary is not
Okay.
available.
In 6.
Motion matter today listed as motion.
15. List this matter on
28.
16/7.
16/7.
16/7.
16/7 for case diary. Item number 6 also. Heard Mr.
Sure, item number 6, I may be allowed to withdraw.
On request of the learned counsel for the petitioner, this case is allowed to be withdrawn. This case is dismissed on withdrawal.
Obliged. I. This case, your lordship, connected with item number 33, say out of same FIR,
86.
86.
Normally 86 is CD is available with me.
Lordship,
86 it is
Yes.
not on.
petitioner Sajidul.
So,
Sajidul is not, my petitioner is not name accused, your lordship, and he was merely arrested on suspicious ground, your lordship. And the impugn FIR is at page 21. Lordship. Lordship, may I read?
Mr. Bothakur, what are the allegations?
yes, my lord,
Your
regarding
grounds are you are not named.
Named and no
Anything
whisper
else?
in the forwarding report also. Nothing has been recovered from my possession. And the co-accused has been released on bail, your lordship.
On what ground you were arrested?
Lordship. Merely on the statement made by the co-accused. The forwarding report is at page 25, sorry. Forwarding
What
report,
evidence is there against?
yes, my lord, regarding the statement of the accused persons, my lord. All the accused persons are, my lord, there is a racket, my lord, all the accused person, not only the, my lord, there are many other cases also, my lord, against the accused
When
person.
were you arrested?
He was arrested on, my lord, in this case, shown arrested on, my lord.
shown,
এটা আপনার কেটে দিয়েছে।
shown,
22, 22,
no, 21.
Sajidul Islam file is not with me, my lord.
He was shown arrested on 21/5, your lordship. And initially, he was arrested on 5/5. And in that case, he has been enlarged on bail, lordship. And subsequently, he was shown arrest on 21/5, your lordship. And further custodial, since there is no whisper in the forwarding, nothing has been recovered from his possession. And considering the detention period also, your lordship, I may be enlarged on bail in any terms and condition, lordship.
This is Hatigao PS case number
86, my lord.
86. And the co-accused also have been enlarged on bail by this honorable court, lordship. I have annexed the order also. One Julhas and one Siraj Ali.
Heard, Mr. Yes.
Otherwise, my lord, materials is there against, in this type of, my lord, what happened, my lord, in all these cases, my lord, one thing is common that, my lord, while those, in those residences, my lord, house owners, members of the, my lord, those houses were absent at that point of time, my lord. This type of theft and, my
Now,
lord,
what materials are?
materials is that those accused persons admitted, my lord. In this case, the present case, my lord, Caesar list, I have not found any Caesar list, my lord.
No,
Till
no,
now,
lordship, I have the Caesar list.
investigation is still going on, my lord. Regarding till now, no recovery.
Caesar list is my hand, your lordship. You may perish the Caesar list also. Nothing has been recovered from
This
my
is the statement of my lord Sajidul Islam and other accused persons name.
Caesar list. From other two accused, co-accused, some articles have been recovered, but from my possession, nothing have been. I am a goldsmith, your lordship, and running a jewelry shop far from Guwahati. It is 70 kilometers far from here.
Sir. Heard, Mr. What is your name?
Yes, Hussain.
Heard Mr. S. Hussain, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely, what is your name?
Sajidul Islam.
Namely, Sajidul Islam,
Lordship.
who has been detained behind the bars, who has been shown arrested in Hatigao PS case number 86/2024 on 21/5/2024.
Lordship.
Before that, the petition 24, stop. The petitioner was arrested on 5/5/2024 in connection with another case, that is Hatigao PS case number 87/2024. The gist of accusation in this case is that on 1/4/1/5/2024, one Rohit Kumar Thakur had lodged an FIR before the officer in charge of Hatigao PS case number Hatigao Police Station, inter alia alleging that a theft took place in his residence at the first floor of Muktinath Housing Society, house number 87, Ajanta Path Survey, under Hatigao Police Station, and gold jewelry amounting to rupees 1,50,000 was stolen therefrom. Quote paragraph number 5 from page number 30. Paragraph 5. Learned counsel for the petitioner, how many days you have already? How many
Already
days have left?
from 20, from 5th, it is 50 days behind the bar. And in this case, I have enlarged on bail, but in shown arrest case,
Learned counsel for the petitioner has submitted that he has been detained behind the bars for last 50 days. And he is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Hatigao PS case number 86/2024 and has submitted that there are incriminating materials in the case diary against the present petitioner. and the co-accused of this case have implicated him. He has submitted that several such incident of theft have occurred in recent past where the modus operandi of the committing crime is similar. he similar, and therefore he has opposed the grant of bail to the present petition. I have considered the submissions made by learned counsel for the both sides and have perused the case diary of Hatigao PS case number 86/2024, which was called for in connection with this case. It appears from case diary that though co-accused have implicated him, however, nothing was recovered from his possession. It also appears that the petitioner, the above named petitioner, has already been detained behind the bars since 21/5/2024. And in the meanwhile, one of the co-accused, namely Siraj Ali, alias Chiraj Ali, has already been granted bail by this court in bail by order dated 19/6/2024, by order dated 1656, 19/6/2024, in bail application number 1656/2024.
And another is Julhash Ali, alias in BA number 1530.
In this case, there is only one petitioner.
Lordship.
In this case, only one petitioner is there.
Yes, your lordship.
Court paragraph number 10. 30,000 with one surety of like amount with certain conditions. Next is
33 Lordship,
same case.
Same
86.
case, Lordship.
Deeply
Same
applied.
Time of arrest, same.
You were shown arrest or
Shown arrested on 21/5/2024. And I was arrested in main case in connection with Article 87, 24/5/2020.
when you were arrested?
I was arrested on 5/5/24.
Originally, shown arrested on 22/5/24.
And in the original arrest was
On 5/5/24.
similar to the earlier accused.
Lordship, similar.
Yes.
In 87/24, you were arrested.
I was arrested and I was allowed to go on bail, Lordship, in that case. By this honorable.
Later, same order. Only petitioner's name will be different. 30,000 with one surety. Same
Published.
Lordship, this is for correction of an order passed by the lordship. The lordship takes up the IA. Lordship at page number 9. On the first line, lordship, page number 9. PR case is 1861 of 2023. Subsequently, lordship, there has been some typographical error in para 7, 8, 11, 13 and 15, and it has been written as 8161 of 23.
What was the 7/8?
Lordship, para 7, para 8, para 11, para 13 and para 15. Lordship, here typographical error is, it has been written as PR 8161 of 23, whereas it should be PR
Para 7, 8,
11,
11.
13 and 15.
What is the actual?
Lordship, the PRK should be 1861 of 23. It has been given as 8161 of 23.
Heard Mr.
M. Das.
M. Das, learned counsel for the petitioner. Also heard Mr. T. Bothakur, learned additional public person. This interlocutory application has been filed by the petitioner, namely Shri Diptendu Banerjee, praying for correction of typographical mistake which has crept in the order dated 2/4/2024 passed by this court in criminal petition number 372/2024. It is submitted by learned counsel for the petitioner that the said criminal petition was referred by the petitioner in connection with PR case number 161.
It's 1861.
1861/2023, which is pending before the Court of Learned Chief Judicial Magistrate, Kamrup Metro. However, due to typographical mistake in paragraph number 7, 8, 11, 13, and 15 of the said order, the PR case has been mentioned as 1861
As 8161 of 23.
8161 of 2023 instead of what?
1861 of 23.
1861 of 2023. So I have perused the certified copy of the order dated. No, I have perused the case record of criminal petition number 372/2024. It appears from record that due to typographical mistake, the case number of the PR case has been mentioned wrongly in paragraph number 7, 8, 11, 13, and 15 of the said order, of the order dated 2/4/2024 in criminal petition number 372/2024. So same needs to be corrected. Hence, it is hereby ordered that the PR case number 8161/2023 appearing in paragraph number 7, 8, 11, 13, and 15 of the order dated 2/4/2024 passed in criminal petition 372 of 2024 shall be read as PR case number 1861/2023. Accordingly, this interlocutory application is disposed of.
Item 60.
Next one.
Again, Miss Nargis is not there. Lordship can take it up on some other day then. Otherwise, I have.
My name is there, but I don't have the file. File of the.
Otherwise, I've seen it's in a packet. It's kind of wrapped by a sellotape. It's not box or something that the quantity will change.
Sellotape.
No, the issue.
Now you get the file, come prepared, we'll take
Tomorrow,
it.
my lord. Tomorrow is possible, my lord.
They are-
Because the plea which we have taken is a bit different, my lord, which we are saying that it is for the prosecution to show that the contraband is of commercial quantity, not for us to show that it is of the intermediate
But
quantity.
they
But they have not, they have specified
that is 24 point such and such gram, my lord. With the packaging, there are 12 separate packets with the packaging with the tape, my lord. Inventory has also been made. The inventory serves as a secondary evidence for the contraband, my lord, for the quantity as well as the nature of the contraband. Now, even in the inventory, it is well packaged with. So it is for the, unless the prosecution establishes that it is a commercial quantity, my lord, we cannot negate something, my lord. It is for them to assert it.
No, but they are saying that it is commercial.
But they are saying that it is with the
With
the
sealed
packet.
packets, that is
Sealed
what
packet.
is written,
So
not, and photographs are there.
yes.
Where
So,
lordship can say.
photographs
that-
will not be able to justify the weightage, my lord. So weightage will have, it was incumbent upon them to show it was. Anyway, my lord, I don't have the file, my lord, we'll fix it tomorrow, my lord. We'll argue tomorrow then.
Day after.
Tomorrow, day after tomorrow, my lord.
They have to,
Day after.
Day after tomorrow, if you want. Yeah.
because you have to show that this
Yes, ma'am.
weight of,
Yes, no, actually, it is for them to show, because for the
no,
readers to come in.
probability of weight, the package weighing 4 kgs
My lord,
or 3 point some kgs.
That is
But
not
we'll have to-
possible.
We'll have to then venture into conjectures, my lord, because now we do not know. There are different weights of different packages. There are 12 packets. Individual weight of packets may vary. So it was incumbent upon them. They should have shown when they made
But
the
will
inventory.
you get benefit?
Well,
No,
we
the
can only
weight-
submit, my
Day
lord.
after
Day after tomorrow, my lord.
Yes, day after.
60, on request of learned counsel for the petitioner, let this matter be listed on 26 or 26/6.
Lordship.
So this is a 438 application, my lord. But one of the perils of being accused of POXO Act offences is, my lord, while on one side, my lord, these offences are generally, if there's a statement of the victim, my lord.
What is there in the office note?
Yes, it may kindly be taken on record if it is possible.
When have you taken steps?
I have taken steps on 31/5/2024,
25th.
31st. 31st of May. Special PP. Raksas Mare, Dulap, yes. I remember 25. I'm appearing as a special PP in this case. So as per the notification, on the last occasion, when the matter was called for on 3/6/2024, the order was already passed in that manner. We have taken the steps on 31/5 through IO of this particular case.
No, you have to take steps in person to the,
Yes, as per the notification. So the CID official has served notice in presence of the OC concerned. So I have informed the IO and there is a notice from my side, and accordingly that was served upon the concerned OC of the Raksasmari police outpost. And the notice got served and the lift of impression of the informant was taken. So notice from our side as per the notification is complete. So it may kindly be, my humble submission, it may kindly be taken on record. Otherwise, I think the option of engaging a legal aid counsel or amicus curiae.
heard Mr.
J. Hassan, special
J.
PP.
J. Hassan, the counsel for. This is a criminal petition.
I am for the state respondent.
My lord, I am appearing for petition.
He is for the petitioner. I am for respondent number 1, state respondent.
Why state respondent has to take steps?
Statement, as per the notification, the duty was cast upon the PP.
Okay.
So this is a POXO related case.
So we have already taken the 3 times steps, madam.
They have taken the, as usual, in the usual process, they have taken also steps.
What is your name, petitioner?
J. Hassan.
As Sharma.
Heard Mr. A. Sharma, learned counsel for the petitioner. Item number 25. Also heard Mr. J. Hassan, learned special PP.